arbitration matter. Could it be on Monday or Tuesday, my lord?
Whenever you want.
Yes.
I'll release it from Pattern.
No, no.
Because I'll not be here.
No, let it be there. Whenever Lordship seeks next, Lordship can take
I'll
it.
be not here till March first week.
Okay, no problem.
On the prayer of Mr. K.N. Chaudhary, Senior Counsel appearing for the petitioners. Come on, list this matter again on 5/3/2024 for further hearing.
Well, in this case, a very interesting point you could find out. Earlier, it was Chief Justice or his nominee. Now it is Supreme Court or High Court.
Is there a change?
Yes.
Can you give me that citation?
Well, that's the act, amendment, section 11(6).
You mean to say that the amended act has not yet been considered by anybody?
Yes. Now, if it is High Court, then there's an inherent power. But the question would be whether it will be a procedural review or a review on merit. If it is review on merit, then it is not permissible.
But that would be a great shift from the.
Yes. So that's the point which we could
I was not knowing.
Find out yesterday. Today I'm tied up in.
No. I'll also examine on that.
Yes,
don't worry.
Yes.
If you find any judgments on that line,
I've got 2, 3.
You can just give it to him before Friday.
Not today, tomorrow.
No, whenever. Friday, before Friday, you can just hand it.
Yes.
No, it is kept
because it's also something very new for me.
Yes. Kept as part heard, my lord.
For further hearing on 5/3.
You
also examine that, what Mr. It's a shift that means.
Yes, my lord.
We'll examine. Interesting.
Made resolution. Item number 51. Is it that matter, my lord, subject combination match? May I pray, my lord, this matter will be taken after the motion matters?
The only problem is today may not be possible because we'll have to rise by around 3 today.
Then, my lord, as per
we'll fix it next week. Don't worry. 19th. On the prayer of the, you inform Mr. Barbuya also.
My lord. Then, my lord, in the next week, my lord, I may not be available. So, my lord.
26th. On the prayer of Mr. J.C. Gogoi, Learned Counsel for the respondents in WPC number 1885/2023 and 1885/2023. List this matter again on 26/2/2024.
I'll inform.
May it please your lordship.
Yes.
Item number 43. I would today pray for an adjournment, my lord.
Why?
My lord, I would not spell out the way I would present. An additional affidavit would be necessary. But I would pray that whenever lordship is available, my lord may fix the matter.
List this matter again after 2 weeks on a date to be fixed by the registry on the prayer of Mr. S. Bonik, Learned Counsel for the petition.
Obliged, lordship. I have the counsel.
May I please your lordship? Well, I beg to item number 22, my lord. In this case, I need to file the affidavit in reply, my lord. My lord, may be taken up next week, my lord.
My lord, I have an objection in this case. Item 21.
That motion matter.
Yes, my lord. Item 21 is my case. This is listed, my lord, for motion. In item 22, notice has already been, my lord, issued in his case. And that has come along with my case only for, my lord, purpose of the consideration of my case. And already.
The thing is that the issue in both the cases are the same.
No, not same. Absolutely not.
Same school?
Same
Lordship, kindly see. My lord,
it's provincialization.
My lord, Lordship will kindly see what he is trying to do. He is trying to put hindrance, my lord, to my appointment. He belongs to a different stream. Even if I go out, my lord, he will not claim he cannot have my seat, my lord, my post.
He's praying for a filing of a
No, Lordship will kindly see. They have filed the affidavit. Lordship will kindly take up the matter. When the matter reaches up, my lord, your lordship will take up. And if necessary, your lordship will adjourn, my lord. Let the matter reach.
Sir, Pita Emi Madrasa.
My lord.
My lord.
Bita Emi Madrasa.
Yes, let the matter reach, my lord. It's for motion, my lord.
We'll renew your prayer. Any listing matters? Court number 23.
Yeah, please, your lordship. I'm appearing on behalf of learned senior advocate Mr. H. Rahman.
Mr. Rahman is here.
Your lordship, item number 47 may be upgraded.
Okay. That yes. After the top of the list matters. 47 after the top of the list matters.
May it please your lordship. Well, a small humble request, madam. So far as item number 5 is concerned, could it be called them sometime later, madam? Some matters may be called up in different courts.
See, records were called.
Yeah, after some time, Mr. Carey is there.
Records is there.
After
I got 2 files. It doesn't contain the decision proceeding, but I have photocopies of entire proceeding.
The originals were required.
Original lordship, we could not find out because he, initially the proceeding was conducted in Depot campus. Thereafter he was transferred to Silchar.
You take a undertaking, you take a letter from your respondents that the originals are not there and these are the true copies. Just give that.
Okay, we can have it on a date.
We'll have it then.
On fifth, lordship, some matter has been fixed on fifth.
Huh.
Regarding Assam University, on that day.
On that day. Or you want me to have two heavy matters on the same day?
No, no, these are not
Okay.
heavy matters.
On the prayer of Mr. S.A.K.L., list this matters again. On the prayer of the parties, list this matter again on 5/3/2024 for further hearing.
For the lordship has heard the matter at length, put it in on a day when the lordship is holding the bench minute.
No, 5/3 I said, but for
Lordship.
further hearing.
Lordship, oblige lordship.
May I please, Lordship, in item number 52 from daily list, we have hired an evidence in opposition, Lordship, that will be brought on record, Lordship.
Yes, please.
Much obliged, Lordship.
My lord, I'd like to mention item number 56, my lord.
Hmm.
Put a supplementary, my lord, this matter may kindly upgrade and take up as a
No,
first.
I've already instructed, don't worry.
But only,
I have already instructed motion matters to be called up first. There are two motion matters in the main list. Third, fourth is yours. It's that appointment. I also know it's 2 o'clock today.
my.
I've already
Lordships,
instructed.
item number 12 and 18. May I pray for an accommodation only? to the
Nowadays,
process?
we see you only for making mentions. After that, we don't see you.
I apologize.
12, what is left?
My lord, 12 and 18. My lord,
No,
there
what
are-
is left?
It is left. There is left. My lord, therefore, I pray. Let it be there.
Supreme Court latest decision
My lord, the Supreme Court latest decision.
has
was-
also taken into account
No,
that note which you are now assailing.
the only difficulty is, my lord, the other case where it was decided that note was taken into account was a seasonal office which did seasonal work. Ours is a permanent office on record. That difference I'll just place before Lordship. Lordship will have it day after tomorrow.
One thing, Mr. Muzaffar,
Hello.
even if you place with that dicta of the Supreme Court,
My lord,
that this court cannot direct for framing of a scheme,
I understand
then
that.
what
my
can
lord.
we do for more?
Therefore, my lord, I have also advised my clients that they may have to move the Honorable Supreme Court for a review to remove that part where my.
You remove
our
that, then
assist-
come down.
Lordship will,
But with
will-
this
Lordship will accommodate me for only today, my lord. I am not in a position to argue today
Saturday,
any of the matters.
Saturday,
Would do, yes, my lord. No difficulty.
item number 12,
And
13,
18.
12, 13, 14, list this matter again on Saturday.
12, my 13, 14, I am not appearing, my lord. I am appearing only on
No,
12,
all the threes are together. Saturday.
18,
70.
item 18.
And item number 18, list this matter again on that withholding of increments. Well, what is there? What is there?
No, this
18.
my lord. And I'll.
You have been given full opportunity and they were so gracious with you that one charge which was you were acquitted in the criminal charge, they have removed that. Only for the absence period, they have now imposed this penalty on you.
I'll come back day after tomorrow. I have not gone through the file today.
On the prayer of Mr. So-and-so, list this matter again on 5/6/3/20.
May I
The other
please,
matters.
may I please, your Lordship? Lordship, I beg to mention item number 7 top of the list, Lordship. Lordship, I am apologize for inconvenience as D. Borgohai is not well, Lordship.
No need, we have already appointed an amicus curiae because you were not here on the last occasions.
Lordship, only for 2 weeks, Lordship, in this, within this
We
period.
hear the amicus curiae, you be here. Let me see what he has to say. Last date, there was no appearance. We found that the case had some merit. So we appointed Mr. Bora as a amicus curiae.
Lordship.
You be here, let's see what he submits. You be here. Assist him, be here.
Lordship, I beg to mention item number 30 and 31. Lordship, I have taken concern of other side. Kindly adjourn for the day and it may come after 2 weeks. Item number? Item number 12?
Item number
30 and
30 and 31. List this matter after 3 weeks on a date to be fixed by the registrar. As prayed for by the Learned Council for the petition.
May I pray for listing, my lord, for motion and
Motion listing 23.
23.
23.
Mayor, sir, so I have to file a additional affidavit that will call for the.
You have filed an additional affidavit. Call for-
May I please, Ashok, I'd like to mention for listing. Ashok,
23.
Whatever-
Court number 23. Court number 23.
My lord, if I may interrupt, I have just come from court number 23. I had mentioned the matter for motion, but I have been sent here, my
No,
lord.
no, it cannot be. It is senior bench is court number 23. Or you make a application in the registry. I'll not break that senior, that precedence.
May I please, your lordship, I beg to mention item number 11, lordship. The conducting council is out of station as it's a brother's voting ceremony today, my lord. I humbly pray that the matter be taken up on 23rd, my lord.
Top of the list matters. Oh, Ms. M. Dev,
Yes.
brother's
Yes,
marriage.
yes.
On the prayer made on behalf of Ms. M. Dev, list this matter again on 22. 22 will be fine?
Oh.
22 to 2024. Yes, madam.
May I please, your lordship? I'd like to mention 27 and 28, my lord. My lord may not. participate.
Item number 27 and 28, list before any other bench without me. Mundam Tuliki.
Deeply obliged.
May it please your lordships. Lordship, for a moment, lordship may kindly take the item of 48 lordship. It has a direction of 10-15 lordship.
Okay,
48 to deduction level.
you have the instructions.
Lordship, I have the instruction, Lord. Director has done the part, but the
Fine,
second lordship.
is enough.
that is
That
another
is
issue.
enough. When it comes up, you just.
Another issue is there, lordship.
Huh?
Another issue is there, lordship.
No.
The,
48 file.
my lord, may kindly go to the two letters, lordship. Issue is there, that lordship, the secretary obstructing the administration of justice, lordship. So I have to place it before the honorable court, lordship. They are deliberately, lordship, doing these things, lordship. I'm sorry to say that, lordship. So, lordship, first is the director's letter, lordship. They again come and again, lordship, another issue, lordship. Second is the lordship, the letter issued by the secretary. My lord, may kindly go to the letter and kindly go to the judgment passed by the honorable court, lordship. What was submitted by the standing council before the honorable court? What is the direction of the honorable court, lordship? They are willfully, deliberately obstructing the administration of justice, lordship. As a standing council, I should not say that. But lordship, I have to apprise the court the proper fact. And I have highest respect to this honorable court, lordship. So lordship, may kindly go to the letter, lordship.
Okay.
And I will not speak a single word.
You need not.
I
It was serially Matinibo.
will
I'll
not
pass
utter
on.
a single word, lordship.
I've got it, I'll pass it.
I will not utter a single word, lordship.
I got it, I'll pass it.
Oblige, your lordship.
আপনি এটা মারেন মোশন গীতা মারেন এই জয়গালিতে একটা অর্ডার করেছিল
Motion item 21, 22.
লুফা কিবা জয়গালি মারিছিল শোন কে আর হচ্ছে
May I please, your lordship?
কারেকশন তুই মারিছিল না না এটা দিছিলাম হ্যাঁ
May I please, your lordship? For item 22, my lord,
Hmm.
I need to file reply, my lord, to the affidavit in opposition
Mr.
filed by the director.
Talukdar was. Where is Mr. Talukdar?
My lord, kindly see the impugned order, my lord. Page,
You come up after some time. He had made some mention. We'll have it after some time.
highly,
After the top of the list,
But-
Mataji.
Twenty-three. Twenty-four.
Only my presence will be recorded, your lordship.
No, we'll have it after some
Oh.
time. Maybe they'll come up after the 24. All of them. Sure.
Deeply
Supplement.
obliged.
Supplementary motion 55.
Me, please, Your Lordship.
Yes.
Lordship, in this matter, what has happened is, there was a merger order issued on 30th of March 2022, wherein the school of the petitioner, which is the amalgamated school, was merged with the base school. And Lordship, at that time, the petitioner was serving as the headmistress of
Regular.
the yes, Your Lordship. And thereafter, what has happened is, Your Lordship, the petitioner submitted representations to the respondent authorities stating that since she is the only headmistress in that cadre at that point of time, and there's no headmistress in the school of, in the base school, Your Lordship, she may be allowed to function as the headmistress of the merged school as well. According, Your Lordship, on 29th of December 23, the respondent authorities issued an order stating that the petitioner can take the charge of the headmistress, Your Lordship.
Page 41.
Yes, Your Lordship.
Mm.
However, Lordship, in the meantime, what has happened is the private respondent number 4,
Mm.
who was working as the in-charge headmistress, is not handing over the charges to the petitioner. And that's why, Your Lordship, since the month of January, it's already February now, Your Lordship, the school is functioning without a headmistress. And in the meantime, the Gunotsav had also taken place in the month of January. Your
That was
Lordship.
held by the other in charge.
Yes, Your Lordship. She has signed and she has put her signatures and seal of the attendance as well, stating, showing that she is the headmistress. Whereas the order dated 29th of 12 clearly states that,
What is your, what? There is already an order. Why should we come in now?
Lordship, because the respondent number 4 is not handing over the charge, Your Lordship. She has mentioned the same thing to the inspector.
Mr. Kaushik is not competent enough. Director is not competent enough to have this order, her orders implemented.
It can be done. And anyways, one of the respondent of do not have the authority.
Not have.
When there is an order.
Because that provision is there in page 2815A
Well,
and 15A.
yes, that is,
Yes, Your Lordship.
and that too also, my lord, the senior most headmaster, he is an in charge.
He's an
He
interest.
is an in charge. It speaks about the regular headmaster.
So what is your submission here
My lord can direct the inspector of schools
to implement this order?
to implement this order. He should, my lord,
We'll
facilitate
direct both the director and the inspector.
it's right, yes.
We'll not dispose it of, we'll keep it.
Yes,
But Ms. M.S. Sarma Hazarika, learned counsel for the petitioner, also heard Mr. P. Kaushik, learned standing counsel, Secondary Education Department. Also issue notice returnable within 4 weeks. Mr. Sharma, Mr. Kaushik appears, accepts notice for response to 1, 2, and 3. No formal notice need be issued. However, extra copies of the petition we furnished to the petition, to the council within 2 days. Full stop. Petitioner to take steps for service of notice upon respondent number 4 by registered post with AD. Also, the petitioner in the present proceedings has raised a grievance with regard to non-implementation of an order dated 29/12/2023 issued by the Director, Secondary Education Assam, by which she was allowed to hold the charge of the post of headmistress of Jorhat Itharthi Vidyalaya. Also, it is the allegation of the petitioner that the respondent number 4, who was holding the charge of the said post, has not handed over the charges thereof to the petitioner till date, in spite of the said order dated 29/12/2023. Also, from the materials available on record, it is seen that the petitioner was promoted to the post of headmistress of Vidyadhar Sharma Memorial High School on 27/2012. Full stop. Thereafter, they said Vidyadhar Sharma Memorial High School was merged with the Jorhat Itharthi Vidyalaya. Full stop. In terms of the provisions of the office memorandum dated 3/8/2021, it is the when two schools are merged, the senior most headmaster shall be of a senior most amongst the headmasters functioning in the two schools shall be the headmaster of the school upon the merger of the said schools. Also, In the present case, as projected by the writ petitioner, the writ petitioner was a regular incumbent in the cadre of headmistress of a high school, but the respondent number 4 was holding the charge only holding the charge and yet to be regularly promoted to the cadre of headmaster. Full stop. The director, secondary education Assam, noticing the said facts, had issued the order dated 29/12/2023, requiring the petitioner herein to hold the charge of the said post, hold the charge of the post of headmistress in Jorhat Githati Vidyalaya. Full stop. In view of the said position and the categorical averments made by the petitioner that the order dated 29/12/2023 having not been modified, the respondent number 4 could not have continued to function as the headmistress of the school in question, comma. Thus, the director, secondary education Assam, and the inspector of schools, Jorhat District Circle, Jorhat, are hereby directed to ensure that the order dated 29/12/2023 is fully complied with, and the petitioner is permitted to function as the headmistress of the school in question. Full stop. Compliance report in this question. Full stop. List this matter again on issue notice report issue name. Notice returnable 4 weeks query. 4 weeks. It is provided that in the event the factual matrix as projected by the petitioner herein above is not in connoissance with what is there in the field, the respondent number 4 is given liberty to approach this court by way of filing appropriate application form, modification and or clarification of the sort.
56.
May I please launch? Here the petitioner said is one of the condition of the advertisement for the post of Hindi teacher in Applied Primary School.
Okay, why should we entertain your application
My lord,
at this late stage?
my lord, petitioner, my lord,
Advertisement is of 27/12/2023, right? Right?
yes, my lord.
So why should we come in today? Because somebody came in time, got an order. Why should we extend that same benefit to you? Show me that law.
My lord, only thing is that, my lord, I am also eligible in this case.
You may be, but you have not come to this court from 27/12. When this court passed orders, you were a fence sitter waiting. Why should a fence sitter be facilitated by this court?
No, my lord, otherwise.
That is what Mr. Kosik is going to submit.
My lord,
Okay. What do you say?
my lord, my only prayer is, my lord, since the petitioner is also eligible, my lord, at least he seeks the equal right of equal.
You are not eligible. We only are determining your eligibility. So we permitted the others to work.
Yes,
So why should we permit you?
my lord, only thing is that, my lord, my question is, my lord, in this advertisement, my lord, the condition they have put it.
Why didn't you challenge it when you saw it? Is there a statement in the writ petition that you saw the advertisement only day before yesterday, before filing this? Is there a statement?
No, my
Then you knew it from 27/12. Why did you come before this court?
lord, that is there, my lord. But only thing is that, my
Similar order. But before 2
Before 2, my lord.
my lord, 2 PM, my lord, I'll let you.
I have made it categorically in
In fact,
order that I
yesterday's
passed
order-
yesterday,
Yeah.
My lord,
that if you don't file it by 2 PM,
my lord,
then neither this proceeding will survive nor that.
Yes.
my lord,
Laha.
my lord, within 2 PM, my lord.
Huh?
Within 2 PM,
2
my lord.
PM. You'll have the order in half an hour. No more.
My lord, my.
It is my department. Heard Mr. K. Singh, Planet Council for the petitioner. Also heard Mr.
Head to delay.
K. Kosik, Planet Standing Council, Elementary Education Department for the
Division.
Education Department. Full stop. Issue notice, returnable 4 weeks.
Execution of 9.
Mr. Kaushik accepts notice on behalf of the respondents number 1 and 2, no formal notice to be sent. However, extra copies of the petition be displayed. The petitioner, by instituting the present proceedings, has raised the grievance. যোৱাকালি মাৰিছিলা নেকি এইটো? কি মাৰিছিলা এইটো? No. এই paragraph 1 to ল'বা তাৰে। তাৰ পিছত paragraph 2 to ল'বা। paragraph 2 মানে প্ৰথম নামকেইটা লিখা আছেতো। আৰু next paragraph আৰু next paragraph same। একদম same কৰি দিয়া। Let's just matter পুৰা same to মাৰি আছে তো তোমাৰ তাত। Writ petition number 692/2024। এইটো যোৱা, এইটো মাৰি কিনে কাৰোবাক এটা পঠাই দিয়া। কাৰোবাক এটা বেলেগ মাতি দিওঁ, এইটো অৰ্ডাৰটো টাইপ কৰি দিব। 692/2024, right? এইটো ইমিডিয়েটলি আহা। মই ইয়াতে চেণ্ড কৰিম। You will have it in half an hour. মানে এইটো ফাইল কেম দিলে। চাই ল'বা এবাৰ, যদি কিবা কাৰেকশ্যন লাগে কৰি দিবা।
Delivery order.
Sorry, madam, pardon, let's say item 51, they have mentioned by the opposite parties. As an interim order that needs to be continued.
Okay, item number 51, interim order se continue কৰি দিব।
51, I'm appearing for second reading.
No, 51 that
They might make a mention by the respondent also.
that item number 51 JC Gogoi mention কৰিছিল এইটো interim order আছে, that will continue. I'll see. No, top of the list. Mr. Dear.
Top of this matter, item number 4.
Yes, Mr. Chaudhary.
Your lordship,
Mr. Monto, those here delivery of orders, if time permits, after the list is over.
your lordship,
Just I want to place my that synopsis.
Oh, you can give it.
No problem.
Synopsis, please.
your lordship, in
Item
item number
number-
1, your lordship.
Item number 1 of, yes.
In item number 1, your lordship actually asked me to produce that particular reply to the second cause notice. I wrote to them, but they have not been able to trace out the records, your lordship.
We'll call it. Mr. Monto, you need not be here. You can just give that synopsis.
Your lordship, just that today, after some time, I actually have a family emergency. So today, there's some personal difficulty. If it can be taken up on Friday, Thursday, your lordship. Saturday, actually, I'll be on paternal leave from this Friday.
Oh,
So
it's a good news.
that's why.
Okay. You need not be here. I will accommodate.
Yes,
But you pursue that second show cause,
second, so
that reply.
yes.
We'll have it if possible. If not possible, we'll have it in the first week. Mr. What about you give your order?
Yes.
Thank you.
You need not be here. I'll pass orders. Yes.
Made to the lordship. My lord, your lordship says that if a written argument could have been placed. I'll give a copy to my friend also.
দেখাত নিচিনা লাগিছিলে। আপোনাক এফিডেভিট এটা
Okay. My only, I know my limitations, my lord, taking into the facts of the case. Only thing, my lord, in the PC Act, Prevention of Corruption Act, prior to the amendment, the situation was there that a public servant will commit criminal misconduct if he does A, B, C, D, or E. I was charged with 1HC. That if
this thing will come now in E there.
now they will come in E. C, my lord, it is the burden of the prosecution, and my lord, this will come with, my lord, E will come where the owner directly shifts over to me.
Okay.
Because
Anything more, Mr.
No, sir, that document I have already given you, Lordship.
Hearing concluded?
my lord,
Parties have been heard at length. Full stop. Mr. P.K. Roy Chaudhary, Lawrence, counsel for the petitioner, has placed on record the written arguments on behalf of the petitioner. Full stop. List this matter again on. I'll not be here for 2 weeks. Immediately after that, we will. List this matter again on 7/3/2024 for delivery of orders. 7.
Lordship, can it be on the,
3. Yeah, delivery of orders taken a file to move.
Lordship, can it be on the next weeks after 7, 11, from 11?
You will not be here.
I may not be here, Lordship, that's all.
You need not be. You need not be. We'll record your name. We'll record you.
my lord, before I leave, if I can make a small submission.
Yes.
My lord, if your lordship takes the other way around, then my lord, if my criminal case may not be prejudiced by submission of my assets and liability, if that much consideration at the end, your lordship may take into.
Or if we hold that this is a independent process and that will not in any way prejudice you, that will also be enough for you.
My lord.
The other way saying
An
it,
observation from my lord,
that other way saying it,
my wife,
this is completely a different procedure.
I
It has got
understand.
nothing to do with it.
I understand, that is.
We'll see. We'll see. But don't worry. If you find, I'm telling you, if you find something more before I deliver my order on that day, you can just point it out to me. What is left here, Mr. Gogoi?
Nothing is left. Otherwise, also, Lordship, the law is well settled by the Honorable Apex Court.
Can you give me one clarification? If you can come to the rejoinder filed by you on 24/3/2000.
Rejoinder filed by the petitioner, Lordship.
No, by the respondent.
Lordship.
24/3/2000.
Lordship, I have, Lord, I have.
You come to page 2.
Lordship.
Down below qualified candidates.
Lordship.
You will find the name Otul Bormon.
Otul Bormon, Lordship.
Huh? A.
He is
PSF.
from Boda district, Lordship.
Sure.
Boda, 100%, Lordship.
Then there is no.
Even otherwise, Lordship, it is a well settled principle of law, Lordship. I just delivered it.
No need. So this is Boda.
Boda, Lordship.
So this was the only thing which I found.
It is Boda, Lordship.
This was the only thing which I found.
It is Boda.
To be there. You are appealing for the petitioner.
Lordship, I'm praying for some accommodation, Lordship.
Why?
My seniors and next in court numbers.
Nothing is here. I've gone through it. The only confusion was with regard to one Otul Bormon, who was appointed with 36 marks, like you got. What is that? You are paying for?
For the private respondent number 6, my lord.
You give me that judgment.
Lordship?
Give me that judgment.
Oh, Lordship.
Yes, what is that? You can call Mr. Goswami.
Lordship.
After some time. But this court will rise early, so before 12 if you can.
Initially, my appointment was cancelled subsequently.
Then you were given in a CAPF, right? You were given in BSF. That was cancelled because you were found not to be from the border district. Then that was cancelled and you were given in a CAPF. CRPF.
Yes, because there is a preference for
Mr. Goswami.
CRPF.
Yes, Mr. Goswami.
Lordship, one of the petitioner has already selected in subsequent advertisement and he was appointed in SSB, Lordship.
Who?
Petitioner remain.
Petition
My
number?
case- Lordship,
Petition number?
petitioner number, Lordship, Bidu Roy.
Okay.
BT Roy petition number 1
So you're not pressing this for him.
for him, Lordship. BT Roy has already been appointed.
So what about the other two?
Other thing, Lordship, as Lordship is aware that Lordship has already relied on the, and that judgment has been passed with preference. They have preferred only the BSF, Lordship.
No. You will have to satisfy me on one more point.
No, I will satisfy, Lordship.
The advertisement required preference of posts,
Lordship,
right?
Lordship,
You had given only BSF.
only BSF.
So BSF, they say cutoff was 45
Yes,
and you got 36.
yes, 37 and 36.
36. 36 because Bidur Roy got 37, others do 36. Now, a doubt was there when I was going through the file that there is one Otul Bormon who got 36 and was given your BSF.
BSF, BT Roy.
So, no. Otul Bormon.
Otul
Bormon. Now, I queried with Mr. Gogoi. He has clarified that that person actually belongs to a border district.
Border district. I am also mental border district.
Okay, show me that.
Lordship,
Show me from your form.
Lordship.
Your
Only
Sanjay Rajbongsi.
only thing is, Lordship, I have stated, Lordship will find
Sanjay Rajbongsi
no joint
and Jointo Thakuria.
Joint Thakuria is resident of Baska BT.
Baska, but
Baska
see,
BT.
that form that is there at
Only
page,
thing is, Lordship, in the form,
it's not
they
there.
have, it is not
Then?
there. That is the case.
It cannot be. You in the form, if you don't spell out,
But
why should they?
Lordship, they have Highland.
The form is there before me.
Lordship, form is there. Form they have not filled up.
Then,
Form they have not filled up.
so
But
only
but
way you
immediately-
can come in, Mr. Goswami, only way you can come in is by being a border district.
Border district.
Both of them have not declared themselves the border.
Border district. That is the case.
What is 0, Lordship? Code is 0.
It will provide it. Close it. Hard case. And
Ultimately, Lordship, that the
it's already, I think, around
Lordship,
12 years,
2011.
11, 12 years. We'll close it.
I understand, Lordship. And regarding preference also, already Supreme Court has decided this case and Lordship has relied on another judgment.
In division bench. That is with regard to IAS, IPS
Assault
officers. So if the Supreme Court said that merit will not do, you will have to also go by the 87, 88 sometime.
Lordship, in this judgment also, Lordship. Paragraph 9, Lordship.
That is, Lordship will Dipti Mali, Pradeep Gogoi.
No, the judgment of the Supreme Court, I think,
Supreme Court
is
Lordship, Supreme Court is Union of India versus Provincials.
provincial.
Provincials.
We'll not go into, we'll only say 2 paragraphs and close it. The grievance in the present proceedings raised by the grievance in the present proceedings pertain to the non-selection of the petitioners in pursuance to a recruitment process.
Lordship, initially, Lordship delete petition number 1.
I'll do that. Selection process initiated by a notice issued by the Staff Selection Commission on 3/12/2021, inviting applications for posts in different Central Armed Police Force bracket CAPF, as well as the Assam Rifles. It's a advertisement for recruitment against vacancies in the post of Constable GD in CAPF and Rifleman GD in Assam Rifles. Also, the petitioners participated in the set selection process, and it is contended that the petitioners' names were omitted from the select list, although they had secured
Above the minimum requirement.
secured marks as follows. लिखना ये यहाँ से कॉपी कर देना. Page 7, 8 to 8. Also, it is the contention of the petitioners in the writ petition that persons securing marks lower than them were favored with appointments either in the CAPF or in Assam Rifles, but the cases of the petitioners were ignored.
And one of the petitioner has been appointed in BSF after filing the petition, they have corrected and he was converted to CRP.
No, that was private respondent. His case, they have explained
Explain and
that because he does not have the cutoff marks for that
that is
border.
what they have corrected.
They have corrected and then he has been given according to his merit.
According to his preference, Lordship, it was given.
CRP.
I had made a challenge before the court by filing another.
Fine, we will not go into all those things. Mr. S.K. Goswami, Lanet Counsel, appearing for the petitioners at the outset, has submitted that the present proceedings is not being pressed on behalf of petition number 1, Sri Bidur Roy, inasmuch as he has already been in a subsequent selection process appointed into a CAPF vacancy, SSB vacancy, into SSB. So the present petition is only being pressed with regard to petitioners number 2 and 3. Also, the contention of the petitioners have been has been dealt with in details by the respondent authorities filing affidavits in the matter. From the affidavits as filed, it is seen that the petitioners are all from non-border areas and had opted only for the BSF, for the vacancies of Constable bracketed GD in BSF. Also, the cutoff marks for recruitment to the BSF in the set selection process was 45. Full stop. The petitioners not having secured the set cutoff marks accordingly were not considered for appointment on merits. Full stop. On merits for appointment into BSF, which was their only choice of posting. Also, the respondents have also brought on record the fact that after exhausting the preferences as was made by the candidates in the merit list, the candidates who had given limited options were again considered for inclusion in a reserve list too, after substituting their preferences as A, B, C, D, E, F. However, the cases of the petitioner still could not be brought within the merit position due to non-availability of vacancies in the said process. The unfilled vacancies now filled up on review by giving the preferences as noted above. The cutoff marks was 52 for CRPF and ITBP, it was 46. The petitioners having secured marks lesser than that, their cases could not be considered even in the review made against the available vacant posts in CRPF and ITBP forces. Also, in view of the said position and also the fact that the petitioners had not disclosed in their application forms that they belong to non-border border areas, non-consideration of the cases of the petitioner against the category of border area candidates cannot be held to be erroneous. Also, in view of the said position, the contentions as raised by the petitioners in the present petition with regard to their non-selection cannot be accepted, and the materials available on record goes to indicate that the petitioners were not offered with appointment orders only on account of the fact that their merit position in the selection process did not warrant such a course of action. In view of the said conclusions, this petition stands dismissed. However, there will be no order as to cost.
Record considering the preference giving. Only because of preference, otherwise they have some personnel appointed below petitioner also, in other group,
No, no, because of the non-preference, I've said that.
because of
If,
non-preference,
I'll modify it.
because non-preference.
My lord may indicate. Lordship, I am appearing for response number one to five.
Mr. K. Gogoi, Lanak, CGC appears for response number 1 and 5. ऊपर में लिखना.
All
Or
pending
Mr.
matter, otherwise, lordship.
Huh?
All pending matter.
Mr. P. Sharma
For 7.
appears for response number 7.
Obliged.
Oblige, lordship.
Item number 7.
Mid list, lordship.
One second.
Yeah.
আপুনি পাব সেইটো ভুলকে হেৰি কৰিছে ইহঁতে। আপুনি পাব ইহঁতে ভুলকে হেৰি কৰিছে।
There is an urgent order. I just will like to sign it.
ময়ো ওলাইছো। Last time. Last week. Voting pending on it. Okay. Oh. JI Provincial. Final good.
Taking a lot of corrections. Hmm? Yes.
Lordship, as part of readings of the office case, lordship, it can be seen that lordship in the pension paper, his mother name is kept as nominee. So when a person is kept as a nominee, it's a well, lordship. So the question of dependency will not come. Suppose, lordship, I have a wife and I keep my mother's name as nominee, lordship. In that case, lordship,
That dependency is already.
That is
Where
the
is
only
that?
thing.
Where is that provision? Where do you get that? The submission you made, where do you get it?
So basically, it is. Otherwise, no, this submission I'm making being very fair. No,
No. Where do I
my
get that?
affidavit is saying my affidavit is saying something different.
No. Where do I get that submission you made?
Then I have to get it, lordship. Otherwise, it's an established principle of civil practice.
Naturally, but that would not by itself.
Otherwise, it will be.
What do you get, Mr. Bora?
Lordship, if I have to just correct one particular point, nomination in terms of Rule 53 would only would be in terms of retirement gratuity and death gratuity.
That dependency will under 54 will still have will
54.
we will see. He has made a valid point. We'll consider
Yes.
it. Yes. What do you say?
Now, otherwise coming to the, I have given a compilation.
This
of-
one.
Yes, compilation of the certain poems. If I may take your lordship to page number 4 of that compilation. Last point number 9. Now, in terms of sub-rule 2 of Rule 54, an amendment is always brought out wherein the rate, the minimum and the maximum income of the dependents is actually prescribed. Now, if I may take your lordship to point number 9 in Rule 54, last line. A, for sub-rule 2, the following shall be substituted.
Okay.
This was brought about by an amendment in the year 2011. And therein, if I may take your lordship, I have highlighted that particular paragraph.
Family of the deceased.
The family of the deceased shall be entitled to family pension under the family pension scheme for central government employees 1964, the amount of which shall be determined at a uniform rate of 30% of basic pay, subject to a minimum of 3,500 rupees per mensem and a maximum of 27,000 rupees per mensem. So here, the per month, even if you take it, the petitioners.
10,000.
10,000.
But here it goes up to 27,000.
27,000
So you mean to say dependency has to be construed in this line?
in this line.
Beautiful.
And so he will get the family pension. Secondly, your lordship, if I may take your lordship, because earlier on last occasion, the lordship actually sought a clarification as to whether the dependent can take pension from two sources. This particular issue was also, it was there in sub-rule 13B.
B.
Now that 13B has been omitted. If I may take your lordship to page number 6, right, that OM of the Department of Personal Pension and PG and Personal PG and Pensions. At last line, your lordship, at point number 4. Similarly, sub-rule 13B prohibits grant of two family pension to a person who is already in receipt of a family pension or is eligible, therefore, under any other rules of the central government or a state government or a public sector undertaking under a
Got it.
and that 13B has been omitted. I have also annexed that particular gazette notification, which is at page number 9. And I have
Both have been omitted.
13B shall be omitted.
So the father receiving a pension cannot be held against him.
Yes.
Great. Then
Both those issues has been. Now, if I may take your lordship, with regards to the preference as to who will get that family pension. Now, I have got this particular clarification. If I may just place this particular.
this is there. This is
So she will automatically get that.
This
Now,
is there.
I have
But
been
the
told-
only problem here, Mr. Bora, is that for dependency, the father's income is looked into.
That is true.
The father's income is looked into, but while giving the pension, it's given to the mother.
But again, if I may take your lordship to the income certificate also, which is annexed to the affidavit of opposition, that is given by the Mozada. Mozada's income certificate is not a valid certificate. It has to be from the circle officer of the DC.
This is Mozada. That is of no use.
Both of them are from Mozada.
But the issue that has been raised here is that he is a government servant. The father.
Yes.
Yes. Have any idea why, whether he's serving in a government?
She is not working her husband. She lives separate
Huh?
from her husband also. Petitioner is lives separately from her husband also. We have filed the same affidavit also.
That we have got. That they have not considered.
But they have not annexed any police verification report also.
And you say the police had never come to your
Never
house.
come to.
Immediate effect. Okay, got it. Mr. Bora, when are you coming back from your paternity leave?
After 10th of March, your lordship.
10th of March.
10th of
And you're going day after,
from Saturday onwards, your lordship.
Saturday. Can you give me a small note on this?
Yes, your lordship.
Whatever you've said,
Yes, sir.
whatever you find,
Yes.
just give me a small note. We'll take your point also.
My submission is not on the quantum of pension lordship. My
But
submission is
the eligibility for pension.
yes, lordship. If it is that if her name is in the pension paper, also she will get.
I got it. I appreciate that point. We will appreciate that. Don't worry. Okay. Mr. Bora, you just give me that note.
Yes. Within this by Thursday.
Whenever it's possible.
By Thursday.
I'm fixing this matter again on 4th. We'll pass orders on that.
Yes, sir.
Right? If Ms. Buragai has anything to say, she can make a submissions on 4th. I think Mr. Bora has covered everything. Thank him for that. Mr. Bora, D. Bora, learned amicus query in the matter, has made his submissions and undertakes to submit a written note covering the submissions that he has made in the matter. Full stop. List this matter again on 4/3/2024 for delivery of orders. Mr. C.K. Sharma Borwa appears for the CGC, appears for the response.
No submit.
Itu a note tamari slip out didibo aru item date.
Item number 8.
Yes.
Lordship, here on the last occasion, Lordship wanted to know, Lordship, whether out of the 49 backlog posts in grade 4, any post is available or not. Lordship, I have the instruction, Lordship, all 49 posts are filled up, Lordship, in the year.
By PWD.
Yes, Lordship, in the year 2016, Lordship.
It is in terms of this series selection.
Yes, Lordship.
Yes, madam. 49 posts were.
Yes, Lordship.
But
The
45 is.
The last page, Lordship, I have flag marked, that's 4 posts in Kokrajhar district, Lordship.
Who has been appointed in Dhubri? You were in, madam.
Grade 4.
No. Which district? Sonitpur. Visually impaired. Sagorika Boisho. Sonitpur. So, what to do now? The exercise gone waste. You have this, madam. Come back at 2. Just go through it. If this is filled up, nothing more is to be done. If you can find something out, let us know. Rakam karo. A copy to madam of your 2000 Matikidu. 2 o'clock.
Okay.
You just go through that. You have a list in your writ petition also.
Yes.
Compare it. And if you find something anomaly, let me know. If not, just pray for a closure of the case.
Your Lordship, I may be excused.
You can go. You can go.
Obliged.
Obliged, Your Lordship.
This thing should have come on record 5 years, 6 years back.
Yes, Lordship, but the petitioner was sleeping, Lordship. They did not mention the matter. It was last listed on 2016, Lordship. After 8 years, Lordship, it got listed.
Madam, let her have her.
Obliged.
Yes. Next.
Item number 9, 10.
Item number 9, petitioner expired recently. 1 week time to given to necessary effective.
When did he expire?
Lordship, I don't know. Yes.
He has already retired.
Lordship,
After retirement, he expired.
Lordship, I don't know.
Who is your senior?
PT Bola, Lordship is out of station.
List this matter again on Saturday. You get your complete instructions. Saturday.
Item number 10.
We'll hear your matter. We'll hear your matter.
Lordship, this is a weak matter.
Huh?
Weak matter, 9, 10.
No problem. We'll hear 10. We'll not hear 9. 9. Petitioner is dead. So it's not similar now. We'll hear 10.
Lordship, my senior is not. Is he in another?
Wherever he is. If he comes, otherwise we'll pass orders. Before 2. Madam, first half itself. After 12, ask him to come. Wait here. We'll see.
Item 10, my lord.
This is that Mohendra Mudai case, that personal post, how can they promote it?
Promote.
But that plea is not anywhere.
That plea is not there, one thing. And second thing, my lord, both the petitioners are junior to the,
92.
Oh,
They
92,
were of
91.
91 and this is of
92, my
92.
lord. That is the thing, my lord.
Item number 15.
I think he has lost interest
Yes,
after
Lordship. Yes, Lordship.
retirement. Nothing is,
Retirement, Lordship.
and he cannot be promoted because there are proceedings all along
Yes, Lordship.
following him.
Yes, Lordship.
None appears for the petitioner on call. Matter stands dismissed for non-prosecution. Will not sign it till 4:50. If you find your colleague, tell them to come, I'll restore.
I will inform. That's good.
Next day.
Tell me one thing, is this organization
Already shut down.
settled? What is there now? Even if I pass an order, what can I do for you?
Proceeding this regard, others matter also pending before the perhaps Supreme Court also Lordship, some honorable Supreme Court. Lordship.
Here the affidavit says you had received 1,57,59,73. 2 checks were given.
This is not correct. Lordship.
You said these have not been resolved. So how can we do it? We'll dismiss it, giving you liberty to go to the civil court. Prove that. Because that will have to be proved now because you're not there.
But Lordship, in the last annexure, their affidavit Lordship kindly see, they have annexed that received 1,59,000. But down below acknowledgement only 53,200. After deduction of this amount Lordship.
You mean to say page 44?
44. Affidavit.
50. That is, see, they say it is with 2 checks.
Yes.
One is at page 42, that is internal page 30.
Yes, Lordship, internal page 13.
That is 61,015.
This is admitted, we have admitted.
You have admitted
Yes.
it. They say there is another amount.
Lordship, kindly.
You are appearing.
No, Lordship, not some other.
Kindly see, Lordship.
No, you can be free to appear. There is no problem. We always welcome everybody to appear.
It is regarding Lordship. Item 12, 13, 14.
Huh.
In those matters, I am there.
But Mr. Bojumdar,
Please,
he
you
has
should have
fixed it.
informed us.
That I'm sure. I'm sorry because I was told us. It's on Saturday.
Saturday again, I will not be.
Kindly see, Lordship. Internal page.
Saturday.
Lordship, if it can be on Monday or Tuesday, I will not be there on Saturday, Lordship.
Need not be. We were about to dismiss those matters. Ask your
Yes,
junior
sir.
to be here.
That's likely to be dismissed.
Let your junior be here. You need not be here. I know you will not be coming. That's why I deliberately fixed it. Yes. Now what to do?
Internal page 15, kindly see, Lordship. Page 15 of the affidavit opposition, Lordship.
53,222.
53,000.
There
After
are 2 checks.
deduction of this amount, Lordship. if
Now, whom should I direct? This body is not there.
Body is there.
Yes.
Lordship. Body is there.
Yes, Mr.
Body is
Or-
there, Lordship.
What happened to this Assam Government Construction Corporation Limited? It was liquidated.
Finance
Huh?
Finance department is there, Lordship. We have.
No. Who will make this payment to you? Because this organization is not there. It's gone.
Already shut down by one body is there, Lordship.
Oh,
For regarding this.
see, you will have to establish this. We can't do that in a writ proceeding. We can't do that in a writ proceeding.
If suppose Lordship admitted 53,000 also, there are.
No. 53 plus 61.
Yes, 60.
Plus another 61,000.
61,000 we admitted, Lordship. We have received, we have annexed. all
First is
documents.
61,326.
Yes, Lordship.
First, before this thing.
Before this thing.
Then there are 2 checks. 61,015, which you say you have received.
No, Lordship, kindly see this receipt. This is 2006, Lordship. This is earlier receipt. Initial 61,000 receipt. Lordship, kindly see receipt signature below accountant dated to 2006, Lordship. This is not later on. This is that amount, Lordship.
Now, you find out to whom we can direct.
Yes, Lordship. Yes, Lordship.
Find out, we'll pass orders.
Public enterprises department, industrial.
Public enterprises.
Yes, Lordship. Commission of
Leha.
Service.
So my lord, it will be now industries. Public enterprise or industry, that is amalgamated. Mr. Kalita, he can.
No need. We'll ask him to make us a representation to them. Because this is cannot be disputed. All are disputed questions. He says he received, they say they paid.
No.
From where will this poor God go and see?
This receipts earlier receipt, Lordship.
Fine, you go make a representation, let them consider.
Petitioner during the pendency already expired, Lordship, his legal heirs is there, Lordship. We have
Okay, we'll look into it, don't worry.
Liberty may be granted.
The present petitioners are the legal heirs of Muhammad Abdul Qadir Chaudhry, who was employed as a driver under the Assam Government Construction Corporation Limited. So, Abdul Qadir Chaudhry had instituted the present proceedings, raising a grievance that the dues as receivable by him on availing of VRS were not released to him as per the calculations made. It is the contention of said petitioner that he had received only an amount of rupees
61,015.
Amount of rupees 61,000
015.
White check number 928313 dated 9/8/2006. Full stop. Shri Abdul Qadir Chaudhry, during the present pendency of these proceedings, expired and accordingly.
Lordship, I am appearing for ADCC, Lordship.
It's not there now.
No, so ADCC has been closed down.
We'll direct the Public Enterprises Department.
No, Lordship, in this particular case, as per affidavit filed by us, everything has been paid.
If he has any grievance, he'll go there.
Lordship.
We'll record that. Had died during the pendency of the proceedings, and the present petitioners, being legal heirs, had implemented themselves, substituted themselves in place of the original petitioner. Full stop. Contrary to the claims made by the petitioners in the writ petition, the managing director of the corporation had filed an affidavit in the matter, and therein had contended that the petitioner was entitled to a sum of rupees 2,20,796. Full stop. It was contended that the petitioner had been paid a sum of rupees 61,326 before 31/3/2006, and the balance remaining dues of 1,59,473 were paid to the petitioner by way of two checks, being check number 928313 dated 9/8/2006 for an amount of rupees 61,015 and 2,87,515 and 53,000, sorry, 53,222 white check number 287,515 dated 21/10/2008. So it is the contention of the respondent corporation that the petitioner was released with his total entitled dues of rupees 2,20,796 on account of the benefits accruable to him under the VRS scheme. Full stop. The said position is disputed by the legal heirs, is disputed by Sri Abdul Qadir during his lifetime by way of filing an affidavit in reply. It is the contention of the earlier original petitioner that he had not received the dues as claimed to be released to him by the respondents and had only received a sum of rupees 61,015 through a check bearing number 928313 dated 9/8/2006. The position with regard to disbursement of dues being disputed by the petitioner, in spite of categorical contentions made with regard with contentions made by the respondents in their affidavit, the said position cannot be resolved by this court by basing on the affidavits filed by the parties and an inquiry into the actual disbursement of the dues and received by the petitioner would have to be looked into, which would require determination of facts. Also, accordingly, the Assam, what is it called? Assam Government Construction Corporation Limited, no longer being in existence, the petitioner is directed to approach the secretary to the government of Assam, Department of Public Enterprises, by way of petitioners, by way of filing a representation and therein highlighting the claims that exist with regard to the services rendered by Abdul Qadir Chaudhary. So the said authority, in the event of receipt of such a representation from the petitioner's hearing, shall cause an inquiry into the matter, and after determining the issues, including the contentions as made by the corporation in the affidavit filed before this court of releasing the amounts due to the petitioner, come to a conclusion with regard to the claims made by the petitioners. Also, in the event it is found that the petitioners are entitled to any amount out of the final settlement dues of rupees 2,20,796, the said authority shall ensure that the amount is so released to the petitioner. From where?
Let's say these checks were paid, account pay check has been paid.
That's it.
That is why how they can deny lots of account pay check, they have accepted.
Now, there is one amount. There is one amount with where there is no account pay check. That first one, 63.
1,000.
No.
There is the acknowledgement.
No.
61,326, Mr. Goswami. That there is nothing.
Kindly see page 25 of writ petition. They are undertaking their memorandum, Lordship. Kindly see page 25. Page 25, 7 paragraph, serial number 7, first line, Lordship. Before
No,
making
there might
payment,
be somebody somewhere.
they have
because
taken
complete
receipt
closure
and
may not have
undertaking
happened.
before releasing the amount, Lordship. As per their
It will vest with somebody. The corporation, that assets will vest with somebody.
Public Enterprise Department is there.
The so and so will last name. Amount is released to the petitioner from the assets of the said corporation if any existing as on date. That much only we can do. If that corporation assets something is there, it's
Yeah,
determined, you get it.
similar various issues are pending before the courts also, Lordship, regarding.
Fine. Only one, that
Lordship.
61,000 something,
Only paid.
you have not clarified that you had said two checks. Two checks, 61,000 and 153,000. This 61,336 something, nothing.
Lordship, one prayer, Lordship.
Your affidavit.
Yes, we have the voucher, Lordship. He has the signature, he has the voucher.
Yes.
It will be produced.
They will file a representation along with the Lordship affidavit filed by the respondent.
The petitioner to submit the representation along with a certified copy of this order and a copy of the representation or a copy of the affidavit filed in the present proceedings by Sri Pavitra Kumar Kolita on 25, Pavitra Kumar Kolita, in charge managing director, AGCC, on 25/4/2014 in the present proceedings. Also, the above exercise shall be carried out, carried out and completed by the secretary to the Public Enterprises Department within a period of 8 weeks from the date of receipt of the certified copy, along with the representation and a copy of the affidavit filed by the before this proceeding. With the above observations, and directions, the petition stands disposed of.
My name is
Mr. S.K. Goswami appears for the respondent number 2, AGCC.
Obliged.
If he is entitled, we will not foreclose that much only, because that amount, I did not find any clarification.
They have taken receipt.
We have the
No, you have not even said that.
They have taken receipt before releasing the BRSS for their member.
That man is gone now.
Yes, yes.
We can't confirm that.
Under pressurized.
We can't
they have
confirm
taken-
that. We can't confirm that, Mr.
Without releasing amount, they have taken.
The item given us in
16.
Obliged.
Mr. K. Hussain. Right.
17.
Yes,
17.
17.
1717, right? No problem.
Lordship, I think, the relief sought by him has already been given.
Given, you're not entitled.
Actually, my lord, I don't have any instruction.
You don't have any instruction. He says he's given, so we'll close it. Because you don't have instruction, because the client has got your relief. And that period you are claiming, he cannot be given, because that average, that ACR, you had put in a appeal.
But my
That
lord,
appeal was rejected.
yes, but my lord, what happened, my lord? He was worked under the reporting officer for a period of 84 days.
Now
For
subsequently.
given the grading, it should be
Subsequent
minimum
lordship, he has
90
been
days.
given with effect from 2013. He has been given from 2013 lordship.
You are claiming from,
2013 he gets,
you got it,
he got it.
Actually, then.
23/8/2014.
Lordship is in the flag pages.
Manas Haldar fit first with effect from 25/4/2013. The petitioner heard Mr. S. Chaudhary, learned counsel for the petitioner, and Mr. R.K. Dev Chaudhary, learned deputy SGI, appearing for the respondents. The petitioner in the present proceedings claims the present proceeding has raised a grievance with regard to the denial to him of his first upgradation under the MACP scheme with effect from 2013. So the petitioner was so denied, they said, benefit on account of the adverse remarks existing in his ACS for the relevant period of time, during the relevant period of time. Also, Mr. R.K. Dev Chaudhary, learned counsel for the respondents, has produced before me an order dated 23/8/2014, by which the benefits of MACP first MACP were extended to the persons enlisted therein, and the name of the petitioner figures at serial number 10 thereof, and he has been granted his first MACP on completion of 10 years of service with effect from 25/4/2013. It may be noted that the petitioner was recruited as a constable in the CISF with effect from 25/4/2003. Accordingly, the petitioner has been granted his due first MACP on completion of 10 years, that is with effect from 25/4/2003, and accordingly, the grievance as raised by the petitioner in the present proceedings stands redressed. Accordingly, in that view of the matter, Mr. Chaudhary also accepts that the petitioner having been granted his first MACP with effect from 25/4/2013, no further issue rises for adjudication in the present proceedings. Also, accordingly, the writ petition stands closed. The instructions as produced by Mr. R.K. Dev Chaudhary is kept on record and marked as X. You can take this back. Only this one. Look right here. Enough? Next.
19.
May pleasure, Lordship. Matter pertains to compensatory appointment, Lordship. A petitioner applied within 1 year, my lord, and response number 6 applied after 3 years, my lord. Petitioner applied for the post within 1 year of his death, father's death, my lord. Whereas response number 3 is, private response number 6 has applied after 3 years, my lord. Initially, it was granted, my lord, that was, therefore it was not listed, Lordship. Matter was not listed for.
You're not interested. If the client was so eager, he would have been pestering you like anything. Shows that there is no necessity.
Devabrata, you are my lord.
Finished.
My lord,
And see, 2009.
yes, Lordship, that's true.
Then what is the compassion required? And you had applied rightly, wrongly for a grade 3 post.
Yes, that's.
That lady applied for a grade 4 post.
Yes, Lordship.
There was no vacancy, grade 3. They considered you a second time.
My lord, as per RTI, yes. Yes, yes.
Then you have done our homework. Don't worry. Anything more?
Yes.
Closed.
Yes, yes.
Dismissed. Bill pass office. Itu. Dismissed. Dispose corrective. Naam kita likhi logo. Yes, next.
Item number 20.
Yes. Assam Administrative Tribunal goes against you.
Lord,
Hmm?
Lordship,
What is left here?
Lordship.
What is left?
Well, Lord, they have not considered the legal
You
aspect.
went on programs in spite of being said don't go by your chief factories inspector. Right?
My lord,
You closed down factories saying they have to be hazardous, but they have that hazardous license. So these are the factors which went against you. What do you have to say on that?
my lord, these are first remarks. They have of 2002, 3 and 5, 6.
This man has retired.
Man has retired in 2012.
What is left?
My lord, and those remarks were, adverse remarks were communicated to him in the year 2007.
And you made a representation against that.
Made a representation.
That representation duly considered.
My lord.
What more is required?
My lord, we
What is the error in that consideration? That you tell me.
my lord, we have approached this honorable court earlier. These honorable court by order dated 2/7/2009.
Page
My lord, 109. In paragraph 12, my lord, that is at page 115.
109.
15, 115.
Okay.
Paragraph 12.
Just. Okay, yes.
The above provisions of the ACR rules therefore unambiguously promulgate the obligations of the concerned authorities, not only to communicate the adverse remarks recorded in the ACR of the employee within the paragraph 12.
Got it.
Time frame fixed, but also to dispose of any representations made against the same within the period prescribed.
You come to para 14. That is the final conclusion.
Lordship, final conclusion here. One for page 117. On a totality of the consideration as above, this petition is disposed of with a direction to the Chief Inspector of Factories Assam, Guwahati, to forthwith communicate to the petitioner the contentions of the ACRs for the period 7, 8, and ending 9. If the petitioner submits his representations against the same, those would be duly considered in accordance with the ACR rules, and the decisions would be communicated to him without delay. As in terms of the ACR rules, delay has already occurred in the matter of communication of such remarks. This court considers it expedient to fix a timetable for the exercise ordered. The respondent authorities within a week from the date of submission of the certified copy of this order would make the communication of the contents of the aforementioned ACRs to the petitioner, and thereupon he, if so advised, would submit his representation within a period of
Got it.
60 days.
Then you made, then
Well-
they communicated that to you. You
My-
made a representation.
My lord.
That
This-
was disposed of on 26/2/2008.
This is regarding my lord 2007, 8 and 8, 9. No adverse remark in this. So they are on the basis of the adverse remarks of 2003 and 23 and 5/6.
Where is this order dated 26/2/2008? By which you come to page 125, paragraph 13.
That sir, the authority did not reassess my merits on 22 for 2002, 3, 5, 6 on the basis of the representation submitted by dated 24/2007, 26/12/2007, dated 17/8/2000, and without any hearing, proper inquiry issued an
So there
order.
were two ACRs, 2002, 2003, 2005, 2006. Two ACRs were under consideration, wherein there were adverse remarks against you. Now, these two were considered in terms of the, you had submitted a representation against that.
Lordship, at that relevant point, when that has been communicated in the year 2007.
You submitted. That
Which
was
I-
disposed of in 2008.
Some of
Where is that order?
26 to 2008. Lordship.
Yes, page 86. Right? You made a challenge to this before the learned tribunal. Right? When were you first considered for promotion to the next higher rank?
96.
No,
Then, my lord,
96.
96, my lord, there's a greater, in 1990.
96,
in
how can we
89.
consider that today, that promotion? After this 2003, 2005, when were you considered for promotion?
In the year, Lordship, 2010.
Your first claim is 2004, 13/10/2004, additional chief inspector of factories, right?
Lordship.
So for 2004 to effect, you will have to get over the ACR of 2002 and 3,
Lordship.
right?
Lordship.
It is written there in that ACR,
Well,
80 or
that
some
is
page
here
80 or
for-
something.
In 2004, when my case is under consideration, at that time, that ACR has not been committed. That has been
Forget it,
communicated.
forget it. Now
2007.
yourself by going to the courts, getting orders, now that has been communicated, considered, retained. And the
During the
retention order
pendency of
is page 86.
During the pendency of the first writ petition, that ACR has been accepted in the year 2005.
Fine. That is at page 72. Come.
(72).
72, sorry, 72.
Lordship,
Okay.
Lordship,
Below average, not fit for competent for advancement to the next higher post.
Lordship,
So this is one ACR.
Lord.
Second one is next page. Below average, not fit for promotion. Right?
Lordship. These ACRs, 2002, 3, 4, 5. These
5,
2,
6.
2, 3.
5, 6.
2, 3, 5, 6. The 2, 3, 5, 6 Lordship. Lordship may come to page 193. Page 193, Lordship.
Hmm.
This is the ACR for the period 1/4/2002 to 25/8/2002.
Hmm.
This is the ACR for the period 1/4/2002 to 25/8/2002.
Hmm.
Here I have been given below average.
Hmm.
This has been signed by the recording officer on 5/4/2003.
Hmm.
That has been signed by the accepting authority on 5/3/2007. Lordship will find below. Then the other part of that year, my lord, 26/8/2002 to 31/3/2003. This has been written in two parts. Here also the another person, the person has been given below average. Here, as the reviewing authority and accepting authority has expired, the remark of reporting officer is final. This has been signed by the undersecretary on 2/2/2008.
Where do you get that?
Page 197.
The second part.
Second part. Then, my lord, 1/4/2005 to 31/3/2006. Page 199.
No, we'll only stick to this. Then,
my lord, page 199 is my ACR from 1/4/05 to 31/3/2006. Here also, my lord, below average. This has been recorded on 5/4/2006.
we'll
And
ignore the subsequent things. We'll only go by the initial record.
5/3/07. This is also signed
Now
on
you tell me,
5/3/07.
these two were then disposed of by way of a speaking order, right?
My lord. So the order passed by this honorable court on 2/7/2009. Here, my lord, it has been observed to consider my ACRs for 2007, 2008, and 2009.
So that, what will happen to that 2002 and 3? You went to the tribunal thereafter?
Hereafter,
Mr. Vega, you went to the tribunal?
Not directly to the tribunal, to the appellate authority, to the commissioner secretary.
Then you went to the tribunal.
And against his order.
Come to the prayer in the tribunal. Page 33, internal page 33.
Yes. My prayer before the tribunal, my lord.
One, expunge the retained
so-and-so in the
2002, 3, 5, 6.
2, 3, 5, 6.
So I am only concerned with that. How can I go beyond that?
My lord.
Right?
Sure, that is
Now, no, you may say many things, but I'll have to be circumscribed by what is there. Now you come to page 86.
In this order, my lord. Court has observed
They
that
have expunged a part.
half part expunge.
The only thing that has been retained
Is that
is misbehavior, insubordination. Negative marks against this remarks are retained. Your that remark with regard to not fit for promotion,
yes.
average grading, not changed.
That's why I'm before my lord, whether
you have not paid for that.
2003 and 3, which has been communicated to me after a period of more than 1 year, my lord. Whether that can be considered. my lord.
You only
Lordship,
say
in page 15 of the order of this honorable court, it has been that the respondent authority in the instant case judged by the above imperatives of the ACR rules have been clearly in default.
so. Now tell me what is the error here? Why you should, your basic claim is promotion. Boils down to promotion, additional chief factories.
That expunging the ACR.
So why should I expunge it? Tell me, why should I expunge it? Explain. Merely saying expansion will not do.
My lord.
You will have to show why this is bad.
My lord, this is bad in this law, my lord, because my lord, these were communicated to, first of all, as per the
Mr. Forget that communication that is gone today. You yourself have claimed that. Even if you go by DevDut, it says communicate, then undertake, thereafter make a review of that promotion. So
Sure.
that communication is gone today. You be on merits if you want to.
It's my lord.
If you want to prepare, I'll give you time. 2 o'clock, we'll take it up. Or we'll take it up on Saturday.
On Saturday.
Only pinpoint that, don't go around.
Lord.
Merit, retention order, what is there? If it is correct, correct. If not, what was missed out? That's all. On Saturday. List this matter on the prayer parties, list this matter again on schema number 17.
Lord.
No, about again. Audio 19.
Item number 910, time being.
Yes.
Lordship, he is not coming to, Lordship, kindly, only for the day, Lordship.
No. I'll dismiss it. Ask him. If he wants a disposal, let him come. I had asked him when he came. He can, if he has some problem, let him come and say. Dio, avale mato. 21, 22 mato. Top of the list, hektu. 21, 22 mato.
21, 22.
My lord, may I please your lordship? My lord, in fact, my lead petition is listed. Along with my lead petition, the other one, my lord, has come. In that case, my lord, already the notice has been issued. My lord, what has happened? My lord, there is a fray between, my lord, the client of Mr. Khan and the writ petitioner in the other case. Because they both belong.
There is one more writ petition.
My lord, one more writ petition, 22. This has been tagged with my matter only for the reason, my lord, the honorable court found that, yes. My lord, in fact, thereafter what has happened, earlier I came before this honorable court saying that 2 persons, my lord, from the same stream, my lord, has been.
Social studies has not been done.
Thereafter, my
You are the only social studies teacher.
I am social studies teacher, my lord. Thereafter, this honorable court, my lord, passed an order, initially staying, my lord, the provincialization of one of the, my lord, candidate, that is the candidate of Mr. Khan. That is at page 14. This was an interim order. Subsequently, my lord, the bracketing application was filed at page 16, annexure 2. In that case, my lord, the honorable court had observed that both the parties, they belong to same stream. They were directed to, my lord, file representation. And since I was deprived, I was also directed, my lord, to file a representation. And this is on record, my lord, that they both belong to, my lord, English stream, language, and I belong to social studies. Thereafter, my lord, the order has been passed at page, my lord, 32. My service was provincialized, and, my lord, the service of, my lord, the client
was an order in pursuance to this order.
Absolutely.
No. The order dated 26/6/2023.
My lord.
This is the order, speaking order.
My lord.
Was a consequential order passed by the director.
Consequential order.
Where? That provincializing your services.
Yes.
Where?
My lord, in fact,
where your services, this is an order which says that you are entitled to provincialization.
I have come for consequential order in this case.
That consequential order in your case has not been passed. Okay.
Now your lordship will see what I have stated. My lord, para 10, my lord, para 7. This is my case. I approached the honorable, the director, saying that please issue the consequential order. Now what they say, it is pertinent to mention, para 7, that pursuant to the said order 26/23, the petitioner approached the office of the respondent to multiple times seeking the consequential appointment order. But to his dismay, he was informed that he was not supposed to have the same easily. He was further informed from the office of the said respondent to, unless he obtains an order from the honorable court to that effect, no formal appointment order would be issued to him. This was informed to me because, my lord, they are aggrieved.
Is there a stay order of that order in the second case?
No, my lord, no stay order.
Miss.
My lord,
Yes.
they have filed the affidavit and
My lord.
record is also ready, my lord.
Yes, Miss
My lord,
Surya.
immediately-
Why that order is not being issued to in this case? Your own order, why are you not complying?
My lord, because of pending of.
This is the second time I am seeing. Morning there was a matter. Director passing orders, but that was director secondary education. Passing orders, consequential actions not being taken. Why?
Well, in this case,
We have not restrained you, have we? Is there a restraint order in your case? Who is the petitioner in the second case?
Petitioner-
Is there a stay?
No, my lord,
then-
but subject to the outcomes of the petition.
But next week, this order should be
No,
out.
my lord, they have filed affidavit. Lordship,
We
kindly
filed
pass an order.
affidavit.
today.
No. When that is there, we will consider. Pass an order.
well, within 2 weeks, my lord.
No, 1 week. It is pointed out by Mr. S.K. Talukdar and counsel for the petitioner that the order dated
26/6/23.
26/6/2023, by which the Director, Elementary Education, Assam, in pursuance to directions passed by this court, has concluded that the petitioner was entitled to the benefit of provincialization of his services as assistant teacher in the subject of social studies in Kesar Vita MBM School,
Dhubri, man.
Dhubri, has not been taken to its logical conclusion, and the petitioner has not been issued with orders provincializing his services in the manner required. Full stop. The pertaining to the same very school, another writ petition being WPC number 4564/2023 is presently pending disposal in the present printing disposal, and therein the issue pertains to the as to who would be provincialized against the post of language
man.
teacher. Full stop. Full stop. Further, this court in the proceedings of WPC number 4564/2023 has not stayed the effect and operation of the order passed by the director. Order dated 26/6/2023 passed by the director, directing for provincialization of services of the petitioner hearing. Full stop. In that view of the matter, on the next day, Ms. S. Shutia shall place on record the further proceedings as taken place after issuance of the order dated 26/6/2023. So if no orders for provincializing the petitioner services have been so issued, Ms. Shutia shall receive instructions as to the reasons existing behind the delay so occasioning, even after the determination made by the order dated 26/6/2023.
My lord, the affidavit has been filed saying that I am entitled to, my lord. There is nothing, my lord. Lordship will kindly say 4-5 times they have obtained the instruction.
Mr. I have passed an order.
Yes.
They'll have to.
Lordship will say, my lord, within 2 weeks they are required to file, my lord.
They will. Ms. Shutia will. Don't worry. That's the niyam. Actually, they are very cooperating with us. They cooperate,
Well,
they come up with answers.
For last 10 years, my lord, he is fighting for this, my lord. Cause.
Let's this matter again on 29/2/2024. Ms. Shutia shall place on record the order provincializing the services of the petitioner hearing, or the reason for not issuing the orders.
That latter part may not be, my lord, because they have filed an affidavit saying that I am entitled to. My lord, affidavit is on record.
There may be
That latter
101
part is
reasons,
given
Mr.
kindly, my lord.
Talukdar.
Lordship will
Let
kindly
it
say.
be there. Let it be there. We'll see. We'll examine. We are there for examining reasons only.
My lord.
Let it be there.
No, I leave it. I cannot have any, my lord, any say on the order, my lord. This is my humble submission, my lord.
Let it be there,
Yes,
Mr.
my lord. I
Talukdar.
leave it to your lordship. my lord.
Let it be there.
Yes, correct.
Then if there is something, they'll come up and say, we will resolve that issue.
Affidavit is filed, my lord. They
I know
say
that.
there is nothing, my lord. This is what my submission.
You don't know. Education department, you don't know.
That I leave it to your lordship.
So far, second case is concerned lordship. My lord,
Sorry.
my lord, so far, second case is concerned lordship. Although there is no interim order lordship, I am not getting salary lordship because of tendency of this case.
List this matter again, both Duta matter, list this second writ petition. List this matter along with WPC number Agotu on 29/2/26.
These are both are tagged,
26
my lord.
26
Tag matters.
29/2/2024.
Both are tagged, already tagged, my lord.
My lord, in this case, my lord, I have filed affidavit lordship.
You do whatever you want to do. We'll first clear of him, then come between your fights. Let him go. Why is he suffering? Let him go.
47.
I only kept it. If there is any reason, I just want them to point out. That's why no mandamus is issued.
Yes, Lordship, no doubt he is
On the
entitled.
next date, Mr. You will have it.
47.
Yes.
May I please,
Okay,
Your
they
Lordship.
bought the
Instruction received, Your
First,
Lordship.
let them place the instruction, then I will submit.
It must mind you must have. Mind you. Part of food really, you know. Part of mind you. What is this? This is a paravise report.
Paravise
Why don't you
copy,
file
Your
an
Lordship.
affidavit so that he can also
Yes,
respond to
Your
this?
Lordship, I will file detailed affidavit. Your Lordship.
These are not instructions. These are paravise replies. Huh? We'll have to now go on reading everything.
Matter of 17.
Huh?
17 matter.
It was long one, Your Lordship.
You have it now.
Yes, Your Lordship.
File
I
this
will file
affidavit
it.
by Wednesday.
Yes, by
Wednesday.
1 week time, maybe.
No. Wednesday. Today is what? Tuesday. I'm giving you more than 1 week.
Saturday.
Saturday is open. Then file it so that give it to him by Wednesday. We'll have it on 26th.
26th. Yes, Your Lordship.
Have this affidavit. Something is there. Do it. Ms. P. Das, Learned Standing Council, Secondary Education Department submits that she has received her instructions and would be filing the affidavit without fail by 22/2/2024. Also, petitioners, the respondent shall file the affidavit with an advance copy to the council for the petitioner. Also, list this matter again on 28/2/2024. Petitioner may submit rejoinder, if any, to such affidavit filed by the respondents. Also, in the event no affidavit is filed on behalf of the respondents by the next date of listing, no further opportunity for filing affidavits would be given, and the matter would be proceeded with materials already available on records. You can take back your instructions.
Yes, sir.
Mr. Rahman, if they don't file, we'll proceed.
Deeply organized.
See, it's in your interest that you file an
Yes,
affidavit.
Your Lordship.
Hygienic matter.
Item number 23.
May I please, Your Lordship. Instruction received, Your Lordship. 23, no?
Main person is there. And at last you have come back.
I'd like to take your draw attention on paragraph second, Your Lordship. It is reported that that the Saptagram High Madrasa, now high school, was provincialized during the year 2013. As per recommendation of the concerned district scrutiny committee under the provisions of the Assam Venture Educational Institution Provincialization of Service Act 2011.
When did that man die? Initially recruited man die? Provincialized man?
Due to the excess post, Your Lordship.
Hmm.
2 posts was available at
I
that
know
time,
that.
Your Lordship.
I know that, madam, I know that. When did that person die? Or he's still working? No, I think he's still
working, Lord.
he's working.
Grade 4 employee. Since 94 he is working.
Okay. Yes, ma'am. You have this. Yes.
Yes, Lordship. Here is a case of a grade 4 employee who has come before your Lordship. In fact, if I can go to the chronological list of dates, Lordship. In 1978, Kapatgram High Madrasa was established for maintenance of day-to-day functioning of the school. And there was an urgent requirement of a grade 4 staff there. As per
Where are you reading from?
Lordship, I'm reading from the pleadings, Lordship.
Pleadings.
Yes.
Okay. You can give me the
Paragraph
matter
page
in short.
5.
Yes. Go on, kindly.
As per resolution number 4, the managing committee held on 28/2/94, the petitioner was directed to join. And on 1/3/94, Lordship, at page 17, is his page 16, 17 is the 16 is the type copy. He was
appointed by the
appointed as a chowkidar as per
Okay.
resolution number 4, managing committee. Thereafter, he joined
on 2/3.
on 2/3/94,
Then
page 18. My lord, then on 24/3/1998, the appointment of teaching and non-teaching staff of Kapatgram High Madrasa was approved provincially. And there at annex here 3, page 20, we can see the name of the Yaur Ali, class 8 pass, class 7 pass. His date of joining and date of appointment is there. In fact, the provisional approval that original is there at page 21. My lord, now in 20 in fact on 27/9/2022, respondent number 3, he wrote to the respondent number 5 directing the latter to file a detailed report that your lordship will find at page 42.
you can also touch page 28, wherein that Syed Ali was provincialized.
Yes, my lord. Similarly situated has been provincialized.
Okay, now page 42.
Yes, my lord. Here, in fact, we can see that petitioner's name was dropped.
What is this page 39?
Vacancy position of teaching and non-teaching staff.
In Sapatgram High Madrasa.
Lord. One grade 4 employee has retired there, Yaqub Ali.
Oh, your school was amalgamated.
Yes, my lord.
What is this High Madrasa? ME Madrasa.
High Madrasa.
What is this High Madrasa? Okay, fine. Then what happened?
Now, my lord, since 27/9/22.
This other school was also provincialized school.
Lordship.
The other school wherein the amalgamation was affected.
Yes, Lord.
Both the schools were provincialized schools.
Yes, Lordship.
Okay. Then?
And at page 38, your lordship will find that this Sapatgram High Madrasa was brought under the Shiksha Mitra scheme.
Okay.
On 27/9/22, this respondent number 3 wrote to the respondent number 5, directing the latter to file a detailed report. Okay? And on 6/10/22, the respondent number 3 again wrote to the respondent number 2 at page 44, Lordship. Is that 6/10/22 inter-office communication,
Okay.
if I can.
So the stand of the respondents is that in matter of provincialization, only one grade 4 post can be given.
Yeah.
Cannot be given two. What is your take on that?
My lord, firstly, this was not there. There was no backdoor appointment in this. In fact, and
I can't go beyond the provincialization scheme. Whatever rights will flow to you will flow under the Provincialization Act 2017. Tell me from that act that your case is liable to be considered. I'll pass orders.
approval order is there, Lordship.
I know that.
Provisionally
Approval
approved.
order is one step ahead,
Yes.
but that is not the final thing. Just show me from the act that you are entitled. We'll have to go to the second one. Not the teachers, the other one, non-teaching stuff. Right? You come to page 90. This is a high school.
High school.
You come to page 97. That schedule is there. Right?
Yes, Lordship.
Come to page 98, high school. One. Already 1 is there.
If any differential treatment was meted out, Lordship.
There is no, you have not alleged differential treatment that you were deprived. The other one is senior to you, and you have not even made him a party. If there is any vacancy, that will be put to recruitment. You will be allowed to participate. You will be given weightage for your service and age condonation. Anything more is required? We can dispose it off.
Yes.
Heard Ms. P. Chaudhary, learned counsel for the petitioner. Also heard Ms. P. Das, learned standing counsel, secondary education department. Appearing for the respondents number 1, 2, 3, 4. Also. Notice upon respondent, notice to the notice was not issued, no?
No, ma'am.
Huh? Notice upon respondent number, in view of the order that is being passed, notice upon respondent number 4 is deemed not necessary. Full stop. With the consent of the parties, the present proceedings is taken up for disposal. The grievance raised by the petitioner in the present proceedings pertain to the denial to him of the benefit of provincialization of his services as a grade 4 employee in Sapatgram High Madrasa. Full stop. The petitioner was appointed in the said school on 1/3/1994 and had joined his such services on 2/3/1994. The school at the relevant point of time was a venture school, and the appointments of the petitioner was duly approved by the jurisdictional inspector of schools, by the inspector of schools, Kokracha. Full stop. Thereafter, the cases of the eligible teaching staff as well as non-teaching staff of the said school were considered for provincialization under the provisions of the Assam Venture Educational Institution bracketed Provincialization of Services bracket over Act 2011. Also, although the case of the petitioner was also within the purview of such consideration, the case of the petitioner could not be recommended for provincialization of his services inasmuch as only one post of grade 4 staff was allotted to the school for the purpose of provincialization of services of grade 4 employees working therein, and there being a person senior to the petitioner, the services of the petitioner came to be dropped. Also, the petitioner has full stop. The further, with the coming of the 2017 Act, the case of the petitioner not being considered for provincialization of his services, in spite of favorable reports in his favor from the district authorities of the Education Department, the present proceedings were instituted by the petitioner. Full stop. Ms. Pidas, the Standing Counsel, Secondary Education Department, has placed before me the instructions as received by her in the matter, which reflects that the case of the petitioner could not be considered in as much as under the purview of the Delegate Act, Assam Education bracketed provincialization of services of non-teaching staff of venture educational institutions bracket over Act 2018. Insofar as an high school is concerned, only one post of grade 4 staff is allotted to the school. So, the schedule to the said Act conforms to the conforms to the contentions as made in the instructions received by Ms. Pidas. Full stop. In that view of the matter, a direction cannot be issued from this court requiring the respondent authorities to consider the case of the petitioner for provincialization of his services. However, from the materials on record, it has been brought to the notice of this court that there is a vacancy existing in the school after its amalgamation with with 654 number Sapatgram Moktab LP School. Full stop. Next one. In view of the said submission that a vacant post of grade 4 is available in the school, the respondent authorities are directed. The respondent number 2, Director of Secondary Education Assam, is required to verify the said position, and if a vacant post is so available in the said school, the respondent authorities shall take steps for advertising the said post through the, what is that called now? State Selection Board.
State levels.
What is that board called, Ms. Pukan? Mr. Kaushik, what is that board called, the new one? That grade 4, grade 3 staff recruitment board?
State level committee. Scrutiny committee.
No.
State level grade 4 recruitment cell.
By the affiliation? To the state level?
Class 4 and class 3, there are two.
Class 4 and class 3 recruitment?
Cell. Recruitment commission. Sorry.
Recruitment commission. In the event of such posts being advertised by the said commission, the petitioner shall be permitted to participate in such selection process, and the competent authority shall also, on an application made by her, condone the overage if any. Also, further, the petitioner shall be considered in the said selection by extending to her weightage for the services as rendered by her in the said school. Also, in the event the petitioner, in pursuance to the selection process, comes within the merit position warranted after affording to her the weightage as indicated herein above, the case of the petitioner shall be considered for appointment against the grade 4 post, against any of the grade 4 posts that may be so advertised, along with the post now available in the said school. With the above observations and directions, the petition stands disposed.
But this commission, my lord, recently has undertaken a recruitment drive, my lord, and the last date is over.
Anyway,
that possibly it is in the
end of December itself, the last date
Thing is over.
for class 3 and class 4.
Anyway, we have made it next round, whenever it
Maybe
comes,
they take-
they'll get it.
Lordship, the petitioner is
One thing, last year recruitment upor likha sun, the petitioner, for the purpose of facilitating her participation in the inquiry, this will give her something later.
Madam.
Participating in the selection process shall submit a representation before the Director of Secondary Education Assam along with a copy of the order. So the Director of Secondary Education Assam thereafter shall take necessary steps for compliance of the directions as indicated, as made here in above.
Lordship, the petitioner is already 49 years of age.
That period you have served, apply under that 51 notification.
1951.
OM. That's a rule.
Yes, it is under the 309.
309 rule. Apply that. For that period you have served, they can condone. For the period you have served, they can condone. And then we have directed for weightage.
Yeah.
If by both this you get it, you get it. Can't help it. I can't help that 49 years thing now.
Great, grateful. Like,
Deeply obliged.
I'm very sorry, but
It's okay, Mr. Goswami.
trial court.
What is there now?
My lord, it's vacancy of 2010.
No, 2010, there are 2 points.
Yes.
One, you are junior to that person, admittedly, by virtue of your MR service. So that junior has been superseded, cannot be taken. Now, you were regularized against a personal post.
Yes, yes.
There is a decision approved by the division bench which says, from personal post, no promotion can be made. Under these two circumstances, what can we do?
That's why, my lord, I'm going to take instruction today. The day after tomorrow, I'll
Saturday.
oblige.
Let's this matter again on
Friday.
Saturday. So I
Oblige.
Hey, Nalagit. 16th. 16th.
Oblige.
24.
Hmm.
24.
Wait, my lord, I would like to place this to judgment, my lord.
Yes, give me.
My lord, in Debabrata Tiwari case, my lord, para 14, and in this Shetty case also, para 7 and 8. In both the cases, Supreme Court.
You tell me one thing. Show me the law which says that the application can be made as per your convenience, not as per the scheme.
My lord,
Your father died in 2008.
Yes, my lord.
You made an application in 2014.
No, my lord, 2008, my lord.
You say 2014,
No, my lord. This is page 13, my lord. Page
but in
13.
your synopsis, it's 2014.
This is my lord, typographical error, my lord. Page 13, I have annexed, my lord. In pleadings, I have mentioned.
Okay. Thereafter, 2008, you made this application.
Yes, 11.
Show me from the documents what you were doing thereafter. How you pursued this matter. That is Debabrata Tiwari.
Yes.
Diligence. Show me that diligence. Till 23. Till page 14.
My lord, I have,
Between page 13 and page 14, show me what happened. Where is your statements?
I have approached, my lord,
Where? How?
not by a written form,
Then?
by a oral form, my lord. They assured, my lord, it will be done, my lord.
No. That assurance came to you in as per your statement in 23. When your mother was asked to resubmit the documents.
My mother filed a reminder, my lord.
Whatever it is, what were you doing from 8 to 30? Just show me that. That is what I have to look into.
My
I'm
lord,
sorry, Debabrata
lord,
requires me to look into.
my humble submission, my lord, as per these two judgment of Supreme Court, I reserved right only to get placed my application
No.
up to the DLC, my lord.
Whether your
Sir,
application is to be placed, that has to be decided. That is my understanding. You can test that.
But I,
You can test that. But that is my understanding. I'm sorry.
my lord, my submission, my lord, up to that extent, only to placing, my lord.
No,
That may be,
you show me what you were doing. Debabrata Tiwari immediacy. 2008, when it happened, that was the need. Now we are in 2024.
my lord, in Shetty case also said that the
Whatever
applicant-
it
the
said.
petitioner should not be suffered.
You
due to the-
suffered, you maintained yourself from 8 to 23. Compassionate appointment means immediate. Year 2, we can understand. But after how many years now?
15 years.
Then show me that law. That you can sit, then one day wake up, come before this court, ask for a consideration. Just show me that law. That's why I gave you time. Otherwise, Devabrata Tiwari is before me. I can't go beyond that.
In Nandi Shetty case also, madam, clearly Supreme Court says in this regard.
Okay,
That
90
could be-
15 years delay.
Not regarding, but they are saying.
No, 15 years delay. After 15 years, the Nandi Shetty was passed. Show me. Nandi Shetty is a law with regard to that change in that consideration law.
My lord, the para 7 and 8, my lord. May I read, my lord, in Nandi Shetty case?
And in Devabrata Tiwari, this has also been gone into. This aspect has also been gone into.
That was Tiwari's my lord, para 14. Supreme Court says that in this regard, only my lord, delay part, Supreme Court says this is the duty of the respondent authorities, my lord. That was rejected due to absence of certain my lord, policies in Devabrata Tiwari's case. High Court affirmed, Supreme Court dismissed.
I got it, Mr. How can we come to your rescue after 15 years? And I'll reframe my question. Why should we come to your rescue after 15 years?
And in this regard, my lord,
You
our-
just answer that.
Our coordinate bench passed also a judgment, my order, my lord. I have just placed my.
That order did not take into note Devabrata Tiwari. That orders did not take note of Devabrata Tiwari. That's the difference. Because that order was not there at that point of time. This order was placed before me and I'm consistently following that. 8 years I have said cases wherein there is 8 years, no explanation. And Mr. Counsel, I have gone through your brief. Not once. Yesterday night also I went, trying to find out something that this is the reason. Nothing.
My lord, my condition is for, is regard my condition, my lord, the present
That condition
which is
is,
also certified by the circle officer, my lord, page 20, which I have annexed, my lord. The condition I have, my lord, categorically stated, my lord.
you
So
you go and file cases for damages, but no appointment on compassionate grounds.
My submission, my lord, I am placing only to the extent of placing my application.
That is the
Thereafter,
dangerous
my
thing.
lord, thereafter,
That
my
is the
lord, next
dangerous
will be
thing.
recommended. I'm not entitled for thereafter, my lord.
Then
Only
why,
for-
if you're not interested for the job, why should we
I'm
place it?
interested, my lord,
Then-
but I'm reserved right to the extent of.
Tell me, why should your consideration be made after 15 years, Mr. Counsel? When you have succeeded to leave for 15 years without compassion appointment. It may sound very harsh, but that is the law. My sympathies are with you, but I can't ignore the law. And if the authorities had not given you, why did not you approach this court? Why did you
My lord-
not approach the higher
My lord,
authorities?
authority communicator, my lord, authority, my lord, kindly see, my lord.
Hmm.
I have annexed, my lord,
Hmm.
that page 16, my lord,
Hmm.
page 16. My application is forwarded by the ADC to the DEO.
Hmm.
Kindly see, may I read, my lord? With reference to the subject and above, I am to
Yes.
enclose this.
It is
What is the authority of this DEO to additional deputy commissioner? If this is the stand of the government, I'm going to recall all my compassionate appointment that orders I have passed. Somoto review, I'm calling it. I'm asking everybody to be considered. If this is the stand of the state. If after 15 years an application is liable to be considered, madam, just tell me that is the stand of the state. I'll allow every application. I want the instructions by 2. Ask your deputy commissioner why he has done it and what is the authority. 2 o'clock. And if that is the stand of the state, that in spite of delay, we will place it before the DLC. Why should I come in the way?
Yes, sir.
On 2023, Lordship, that petition, after receiving that petition, Lordship, they have.
You clarified that,
Yes,
just
sir.
clarify that. It was just that petition was received, we placed it
Yes.
without looking into anything. Then I'll pass orders. Get that clarification.
Yes.
Can you, by 2 o'clock?
Yes.
2 o'clock.
Item 25.
Yes.
Have you seen that instructions?
Yes, Lordship, but Lordship directed them to produce the record, Lordship. But
They have produced something.
they have produced only those papers, Lordship, which were already annexed with their affidavit, Lordship. So record.
Show me that. Where is that?
Petitioner
Ah,
was there.
Where is Mr. Fukan? Call him.
I have already informed you.
Yes. She's right. Why the records have not been produced? You are appearing, sir.
Yes, my lord, I am appearing for respondent number 11.
You are appearing for?
For respondent 9, Lordship. Here, Lordship, this is an amalgamated school, Lordship. This is incident happens to the earlier provincialization of the school, Lordship.
Oh, you were not there?
Actually, I was.
You are the headmaster.
Headmaster was not implemented, but as per the order of the Honorable Court, I have appeared, Lordship. And Lordship, documents are Lordship disputed, Lordship. So far, my unless a criminal case is also pending, Lordship. For some regarding this documents, Lordship.
Okay. Police has
Against the
seized it.
petitioner, Lordship. Yes, he is in charge-sheeted, Lordship. Petitioner is charge-sheeted, Lordship. The case is
Petitioner?
now, Lordship.
Where is that?
Lordship. Lordship, the status, open the status, Lordship. Yes, status, Lordship. This is.
Where is the FIR?
Lordship, I cannot obtain, Lordship. Lordship,
Yes, madam. What is this? Modern Talukdar, state versus Modern Talukdar.
I have no knowledge about that, Lordship.
420, 468, 471.
I have no knowledge about that.
Probably after filing of this petition, Lordship, 2016, it is shown as.
I may be given a copy, Lordship. I will take instruction regarding that, Lordship.
The Learned Council appearing for the respondent number
9,
9 as submitted that. With regard to these documents, those cases, with regard to the documents, including forgery thereof, documents are relevant to the issues arising in the present proceedings, including submission of forged documents. A criminal case was instituted against the petitioner in the year 2000. Was instituted against the petitioner, and the same has resulted in the petitioner being charge-sheeted therein. Full stop. The petitioner, the counsel for the petitioner, contends that the same is not to her knowledge, and accordingly prays that she be granted some time to receive instructions thereon. Mr. Fukan, you were supposed to produce the records.
Lordship, on the last occasion, I have produced the records. Lordship had asked.
No, the file you had produced.
This thing we had produced
I don't want the document. I want the file.
Lordship, the file, they were not able to trace. I had given the thing, Lordship, but then they had given the name was not there.
No. Where is that? That document is here.
Lordship.
That document that you have given, it's here.
It's there.
It's here. So we want the records.
Records, Lordship. Records, the other thing, Lordship, there only it's given, Lordship, the main, because it was, it's a very old matter. The person who was there, the DEO, it's, I think, given there, Lordship. Lordship sees, they are not being able to trace the original thing, Lordship.
No, the file would be there.
The rest of the things, whatever.
And
is
I'm
there,
told that there is a criminal case also pending. Have your instructions?
Lordship.
What is the name of the private respondent?
Mohit Roy.
Huh?
Mohit Roy.
Which way?
And the school is Dokhin Kamrup School.
Nalbari MD School.
What is this? This is something different.
Lordship, earlier the school was Nalbari ME School. Now this is Nalbari, this is high school. After amalgamation, Lordship.
Where is that thing you placed before me, Mr.?
Lordship, the last occasion I had given it.
Not here. I think I gave it back.
Give me some time, Lordship, I'll get my instructions. Because last time I submitted the instructions, Lordship, where they had said that the
Belet case or yata kumaya sir.
original file.
Hmm? No, but it case on no. Belet case or 2003 was to. Hello, sir. This is another. Mr. Ekini hold some time to stop. Mr. A. Fukan Learned Standing Council, Elementary Education Department submits that the records as called for by this court is not traceable. Puts up the competent authority under whose custody the said records were to be maintained shall certify that the certify that the said records were not traceable and also bring on record the steps taken by the said authority after the said records had become untraceable. That is, if any police case was filed in this connection. Also, if not, as to why such action was not taken. Also, list this matters again on 5/3/2024. You can take and give it to her.
26.
Mr. Fukan, check up.
May I please this, Your Lordship?
Hmm.
I'm extremely sorry, Your Lordship. Your Lordship, on the last occasion, it was given direction to us, Your Lordship, to obtain instruction. Instruction does not arrive, Your Lordship. It is still awaited. So kindly grant 1 week time.
This case is covered by the judgment of the division bench. Anyway, if my learned friend wants, I have no objection.
Division bench judgment.
Yes, madam.
Which case?
It is with me, madam.
What does it Pradip Sharma?
Pradip Sharma also is there, but the division bench judgment is lordship. This is no police. Police no. This is the judgment that our honorable the division bench mother held that the.
What is the name? What is the name?
What his name is, my lord? What his name is? Sanjay Kumar and others, Passage Union of India.
Oh, that cap matter.
Yes, lordship. The honorable High Court held that.
And you want me to apply all this law in Nalbari teacher recruitment matter?
What happens if they?
So, Soikia, you want me to apply all this law in Nalbari teacher recruitment matter? Okay, I'll apply. Now come to page 20. Page 20.
Of the judgment.
Your writ petition.
Page 20, yes.
Okay. This is the appointment order.
This is the appointment order.
Now tell me,
before,
under which law this appointment order was issued?
my lord, that is true, but before.
No. if that is true, that is the end of the
No,
matter.
no. The-
If that is true, Mr. Soikia, that is the end of the matter.
I am not insisting this one.
Then you are
I am
insisting,
insisting on the selection,
you are insisting on page 35.
selection.
You come to page 35. Soikia, this is the appointment which gives you permanency.
Yes, this selected candidates.
Okay.
Where the candidates?
Okay.
My submission
Okay,
to Lordship,
okay.
just a minute.
Okay, this is the first time you are having appointment. That is 2009. Show me the selection preceding this.
Selection.
If
yes,
I have to apply this,
No, selection.
if I have to apply this,
Lordship,
if I have to apply
I
this,
will read that paragraph because if this selection after selection, my lord.
where is that selection? Show me, Mr.
Yes, my lord. That I'm showing you, Lordship. Page 27, 28 may be seen. List of
Okay,
candidates, yes.
this show me that this was in pursuance to a selection process.
Yes, these are persons appointed,
Excess in terms of the,
just a minute, my lord. They did not put the records. What's your condition serial number 8? Basab Pathak was appointed on regular basis in 2003. Then your lordship, Khonaganda Kolita serial number 16. On that they also made the submission.
Khonakalta,
Khonaganda Kolita.
Pradip Sharma.
Pradip
Pradip Sharma was appointed with you.
Salary is released, arrear salary. And my
No, where is that material to show?
If my arrear salary is released, automatically I will get the old pension.
Show me for that. Now this court will not follow the directions of the authorities. Pradip Sharma was released the material by the authorities.
Now, lordship,
is there an order of this court?
Yes.
Where? So that I am bound to follow. I'm not bound to follow the authorities' orders. I'm bound to follow the orders of this court.
Lordship, the judgment as per judgment of the honorable court.
Where?
Kindly see, my lord.
Last date also you were supposed to produce that judgment. Pradip Sharma.
I have forgotten. Anyway, you lordship may be correct, but you lordship.
I'm not correct. It's all recorded here.
No. The record, order was passed directing them to put the records.
No. Give me that order.
Lordship, kindly see, I may be wrong sometimes.
No. You are right. But let's put the facts in perspective.
Kindly see, my lord, at page 31. Lordship. Page 31. With reference to the above, I am directed to inform you that the government agrees
I
to
got
the-
it.
Yes.
I got it. I got everything, Mr. Soikia. Show me. Show me that person who was adjusted with you, along with you,
my lord,
in page 35,
my lord,
is being now given pension, and there is a direction of this court. Others are not bound to follow this.
No, my lord, just a minute. Lordship, kindly see, my prayer is what? In my petition that if the candidates who are selected, but for the delay of the government, if appointment letter is issued.
Mr. Soikia, there is no selection. It is just a list of excess appointees.
It was the selection. That is let them put the records.
No, you establish.
No, I have, yes.
You establish. You are relying, Mr. Sharma, Soikia, you just come to the additional
my lord, then Lordship, kindly see.
additional affidavit.
My lord, they did not file any objection.
No, you come to the additional affidavit.
No controverted, it is not controverted by the director.
I know that.
Then?
I know that. That is why I wanted page 10 of your additional affidavit. Para 3.
Para?
3. Page 10, para 3.
Para 3, yes.
Direct, read that.
Yes, my lord.
That as per direction.
Adjusted my client against a vacant sanction.
As per direction of the Honorable High Court, the Education Department adjusted my client against a vacant post.
No,
Get me that order.
This is a typing mistake. Oh, your lordship is correct, typing mistake. There was no direction.
It cannot be a typing mistake.
No.
It was a typing mistake in the writ petition. Then you filed an additional writ affidavit to bring on record the correct copy.
No, that lordship, I filed this petition that notice, Peter's notice was wrong. That is why. Oh, Lordship
Okay.
has pinpointed this
Okay,
correct.
okay.
My lord, for the ends of justice, Lordship, Honorable Singular also, who was similarly situated, has considered the case, this is the case, Polias Polita, that for the delay in appointment, the petitioner shall not suffer.
Yes, Mr. Kaushik,
My lord.
what is your case?
But we are still awaiting instruction, my lord.
See, Mr. Soikia is here before this court descending the third time.
My lord.
How long will he come?
But I understand.
Every day it's that.
My lord, I have brought the judgment of Port Sharma. I'm sorry, I have brought the judgment.
Produce some, show me that.
Regarding area.
So I am right in asking that.
Now, you Lordship is very brilliant. Only thing is that it takes time for us.
It's the other way around. It takes time here.
Last parameter, directed to page area.
On the next date fixed, Mr. B. Kaushik, Lanit, Standing Counsel, Secondary Education Department shall receive instructions as to the manner in which the authorities had complied with the directions that were passed by this court in the case of Sri Pradeep Sharma in the wide order dated 14/2/2008 in WPC number 1801 of 2021. 2001. It is to be noted that Pradeep Sharma and the present petitioner hearing were adjusted against a regular sanction post wide an order dated 18/2/2019 prospectively. So, however, the petitioner contends that said Pradeep Sharma has been released his area salaries from the date of his initial appointment and accordingly has been brought under the provisions of the Assam Services Pension Rules 1969, whereas the petitioner hearing has been kept out of the said rules on account of the fact that his area salaries were not released to him. Also, list this matter again on 11/3/2024. You have your instructions.
I'll get it.
I've put the judgment also there.
No,
If he is been given from that date, you cannot deny it to the petition.
29.
That much only I want.
Yes. Actually, from that selection list, most of them have got.
I will not again say that is a.
That record, had they been producing records,
Yes.
that would have been very clear. Oblige.
Yes.
But we have got our instructions. Let's move.
So what is it?
But we have the administrative control over the education institutes.
So you can regularize their
No,
services
Lordship.
then?
If appointment of teachers is done by APSC, Lordship. So they are the authority who will
Then
regularize.
how come the earlier round you had gone for a cabinet decision?
Pardon, Lordship.
You had done through regularization through cabinet decision.
Yes, Lordship.
One space. Similarly situated candidates. And you had placed their matter before the government also.
Yes, Lordship.
The government has not responded. Why?
Yes, Lordship.
Why? Any answer to that?
That reply I don't have, Lordship. Bottom.
Yes, Mr.
The Lordship desire to know, my lord, two aspects. Extent of power of the council with regard to delegated subject, that is college education, reflected in the order dated 19/1/2024. The competent authority of the seat college shall also apprise the court as to the extent of power exercised by the council with regard to functioning of the hub.
They have now brought it on record. They say that the college education has been delegated.
Now, my lord, I'm not privy to the instruction my learned friend has produced.
No,
but what-
we'll have it before you.
What appears is that, my lord, they are taking it as if it is a new recruitment. to
That's what
APS.
they are trying to project here.
Yes.
That your services were terminated by the government. And then they, for the interest of students, have put you in 3F, got no connection with that. That's the stand.
That is what. Now, my lord, we have to go through the affidavits file. The additional affidavit of the principal secretary filed on 23/11/2022 says that NC Hills Autonomous Council has power to appoint. That is one aspect. But I don't think, my lord, that is the correct provision.
That's why we have wanted this clarification.
Now, the initial appointment of the petitioners as well as those whose services have already been regularized, that was pursuant to a selection process.
Selection process held by?
By the college authority itself, my lord.
No, that is the problem.
No, what I'm trying to impress upon your lordship is that, my lord, initially when these persons were appointed on contractual basis, it was informed to the government. The Director of Higher Education was aware of that. And thereafter, it was the Director of Higher Education who had initiated the process of regularization of the persons who were working against on contractual basis. Those are all part of the records. Now, it is not true to say, because that was a submission made on the earlier occasion, that the Director of Higher Education or the government has no knowledge about the appointment of these persons. That falls true from the document itself.
Now tell me, what relief can we now at this stage give you? We can't regularize your services.
My lord, the court cannot regularize, but then, my lord, in the process of consideration of regularization, some other persons have been regularized. We were not regularized for the simple reason that at that point, relevant point.
You did not have the UGC norms.
We didn't have the. Now we have at least out of the 3 petitioners, 2 have acquired the those eligibility.
Still one is left out.
3 is, my lord, about to complete the PhD. It will, I'm told, my lord, it will come in 3 months, that PhD degree. Anyway, that will be a consideration, maybe at a later stage, subject to what your lordship says about the petitioner number 1 and 2. And it is not a case of negative equality, because those persons and us were considered at the same time. And we were not regularized.
No, there is a distinguishing factor. In that those persons who were considered at that point of time had the requisite qualifications. You did not have. So that rejection is not bad. But they have not contended that if that is a one-time measure.
No, they don't say it is a one-time.
They have not contended. That's why you have that breathing space still.
Yes, I deserve the, my lord, same consideration now. And there are vacancies because this.
The council can do nothing here. It has to be by the government.
It's only by your lordship, my lord.
No, the government. Who is appearing for the government? Higher education? Yes. We'll hear this matter, Mr. Chaudhary. Cannot be done on piecemeal basis. Everything, pleadings are complete now. Everything is here. And the instructions. Give a copy of this to Mr. Chaudhary also. Your name?
C. Sharma.
Mr. C. Sharma, Learned, Standing Counsel, NC Hills Autonomous Council, has placed on record the instructions received by him in terms of the queries raised by this court-wide order dated 19/1/2024. He is required to furnish a copy thereof to the petty counsel for the petitioner. Also, the parties have exchanged their pleadings in the matter, and accordingly, the case is ready for consideration for disposal. Accordingly, list this matter again. When do you want it?
First week of March, my lord. First or second week.
On 12/2/2024, on which date an endeavor would be made to dispose of the writ petition. Other than those decisions in Uma Devi and all those things, there are decisions which, with regard to college teachers, and you will find that Supreme Court is not very,
Your worship is right.
very correct. So kindly try to have some judgments which may go.
In the meantime, my lord, on 6th of December 2022, they have issued an order extending our contractual.
No, that will continue. Let that continue. That we have not restrained. Let them continue.
That is for a period of 5 years now.
5 years, fine, very good.
By that time, my lord, perhaps one of them will retire.
Retire. 12/3. It would be not 20. A copy of the instruction as furnished by Mr. C. Sharma is kept on record and marked as ex-blank.
The interim order.
Interim orders possibly shall continue. Mr. Chaudhary, that judgments would be required because what I have may not be.
Will be
I've
trying
said
to
Supreme Court is very clear, categorical on this.
find some leeway, my lord. That's what my endeavor will be.
That's it.
Obliged.
Obliged, Lordship.
Everybody?
32.
Yes.
My lord, in this case, my lord, as per affidavit of the respondent lordship, private respondents lordship. My lord, both the respondents are junior to me lordship. Now, my lord, case is, my lord, the petitioner was the Arabic teacher lordship. My lord, other 4 teachers were provincialized lordship, sir. The enrollment is high lordship. My lord, as per section 3 lordship, my lord, 3 is compulsory. Science, my lord, science teacher, language teacher, and my lord, social science, my lord. My lord, beyond these 3 course lordship, all others should go, my lord, on the seniority basis lordship. If that is so lordship, then my service ought to have been regularized lordship.
The government has filed an affidavit.
Yes, ma'am. My lord, government.
The only plea there is that your case was not recommended by the DSC.
Not recommended lordship, but that is on the count of a wrong, my lord, calculation lordship. My lord, kindly see page
that the authorities need not waste their time filing a affidavit of passing orders. Don't they? They do they think that we don't know about that facts, or we don't read our briefs. We know that DSC has not. That's why, because that's the reason, sole reason why he is before you.
Sure.
And that's why section 14 is there.
Yes.
And again, you come back and say every time DSC is not considered. Reams and reams of paper are being wasted.
My lord, as per affidavit, my lord.
We'll consider. Not today, we'll consider.
My lord,
We'll have to remand this matter, Mr. Only a few days more.
my lord, that may be fixed day after tomorrow lordship.
No.
I am retiring lordship in August lordship.
August. We'll have it on 20th, 20.
Lordship.
List this matter again on 22/2024. Please point out that aspect before any bench.
Yes. All right.
Yes, what did you get?
The names are not similar, Lordship.
Right.
My submission is that what about the
We
selection?
tried, we pursued, can't help it.
Then what about the selection list, Lordship?
That is now, madam, if they have appointed, the only grievance was it was not appointed. Now they have appointed from that list. The posts have been filled up, 49 posts were there. We can't go and direct them to now again consider your case. For the last around 4 or 5 days, we have been doing dates, we have been doing that only, pursuing with them. Blind boy, we also have our sympathies with him. Can't help it. We'll give it a closure. You tried your best, ma'am. More than that, we can't. Next time, better case. Heard Miss
Nanda.
Nanda, learned counsel for the petitioner. Also, Mr. D. Bora, learned. D. Bora is additional government advocate.
No.
D. Bora,
Junior
junior government advocate. appearing for the respondents number 1, 2, 3. Also heard Mr. You heard
D. Upamanya.
D. Upamanyu, Learned Counsel appearing, Standing Counsel Health Department appearing for respondent number 4, 5, and 6. The issue raised in the present proceedings by the petitioner pertains to the non-appointment, pertains to his non-appointment against the vacancies identified for persons with disabilities. What is the name nowadays? It's not persons with disability. Now it is called persons with benchmark disability. Also, the recruitment process was initiated in the year 2005. Also, it is the contention of the petitioner that he was enlisted for appointment against the post so available in the Health and Family Welfare Department. The selection process was carried out by the Social Welfare Department, and the select list was thereafter forwarded to the Health and Family Welfare Department for appointment of the person so enlisted therein. Full stop. The select list validity had expired in the year 2011, and thereafter, in pursuance to directions passed by this court, the list was acted upon and persons appointed. Full stop. On the said aspect of the matter being brought to this notice of this court had required the respondents to receive instructions as to the manner in which the select list was being acted upon. Full stop. The authorities in the Social Welfare Department had apprised this court that the list as available, a list prepared for the Health and Family Welfare Department against visually impaired category were forwarded to that department and appointments were being effected thereon. Also, Mr. D. Upamanyu was directed, Standing Counsel, Learned Standing Counsel, Health and Family Welfare Department was directed to receive his instructions in the matter. Full stop. Accordingly, Mr. D. Upamanyu has today placed on record. Where is that? I gave it back or what?
Lordship, this one.
The instructions as received by him. It is contended by Mr. D. Upamanyu that there were 49 vacancies which were identified in the Health and Family Welfare Department under the Director of Health Services, Assam. Also, and accordingly, while order dated 6/12/2016, 45 persons therefrom were appointed, and the appointment so made also includes persons with benchmark persons with visual impairment. Full stop. It is also highlighted that in the Bodoland Territorial Council area, another 4 vacancies identified were also filled up from the list as forwarded by the Social Welfare Department. Full stop. It is contended by Mr. Upamanyu that the petitioner, not being within the merit position, could not be adjusted against the vacant posts so available in the Health and Family Welfare Department, and accordingly, the case of the petitioner could not be considered. Full stop. The said appointments were effected in the year 2016 and 17, respectively. Full stop. The petitioner's case being that she being enlisted for appointment in the list as forwarded by the Social Welfare Department, she was entitled for appointment from the said list. Full stop. The Learned Counsel for the petitioner was requested by this court to peruse as to whether the persons placed below the petitioner had been so accommodated by the Health and Family Welfare Department from the select list in question. Ms. U. Nanda, on perusal of the select list available on record with the appointment order dated 6/12/2016 and what is the date of the second one? 31/2017 has fairly submitted that the petitioners, persons above the name of the petitioners, have been so accommodated from the list in question. Full stop. And further, she has stated that the persons who have been so appointed also figure in the select list. Also, in that view of the matter, at this distant point of time, this court is not in a position to issue any direction for further operation of the set list or appointment of the petitioner. Also, however, it is to be noted that in the event the petitioner fulfills the requirements with regard to, fulfills the eligibility criteria for recruitment against any such exercise that would be initiated in the future, the case of the petitioner shall be considered on merits. Also, with the above observations and directions, the petition stands disposed of. Sorry, we tried our best.
24.
Obliged, Lordship.
Much obliged.
May I please, Lordship? Prior to Lordship, Debabrata Tiwari judgment, Lordship.
Huh?
Prior to judgment, Debabrata Tiwari judgment, Lordship, there is some direction of the Honorable Court, Lordship, to place the matter before the DLC, Lordship. That's why, Lordship, after receiving this application, Lordship, the ADC has written the letter to submit the proposal, Lordship. They have.
Okay.
I've written instruction, Lordship.
We will now from today onwards, we'll direct everybody to be placed.
Lordship, no,
20 years, 30 years, we are not going to look.
No, Lordship,
If that is the stand, why should we deprive it?
2008 application, they have never received, Lordship. They have written, Lordship. Only 23 application they have received, Lordship.
Oh, that is there.
Yes, Lordship. It is clearly mentioned, Lordship. And that representative has no sign, no endorsement, Lordship.
Okay.
Yes,
Yes, Counsel. I understand. My feelings are also with you. But see, I'll have to take into account every factor. In that, maybe one case somewhere may suffer. But when we have put an yardstick, that see, delay defeats the purpose of compassion appointment. When the view is taken, I can't go beyond that. Until and unless you can show that you were pursuing the matter in the right earnest. Next time, get a better case. We are with you.
My lord, I can say, my lord, my humble submission. Then, my lord, my case may be disposed of on the strength of this communication. By
This communication only.
ADC to the BDO.
This communication and Debabrata Tiwari, both together.
Debabrata Tiwari, my lord.
That you leave it to me.
Only submission, my lord.
That you leave it to me.
14, my lord.
That you leave it to me. You can always, it's always open to you, the higher forums. But you will get it by Saturday. Your name?
H.R. Chaudhary.
H. Ahmed.
H.R. Chaudhary.
H.R. Chaudhary. Disposal.
Apply.
I'll pass the orders. Not today. Tomorrow I'll pass. You'll get it by Saturday. You can file an application for certified copy.
Bless you.
33, 34.
Lordship.
Item 33 may be taken up, Lordship.
Well, if the Lordship take the 34, that will be more convenient, my lord. That is all cases made out in 34.
My lord, in 34, my lord.
34, who is the petitioner?
Yes, I am for the petitioner, my lord. We have some difficulty on today, my lord. Your Lordship may heard on.
No, we are not going to hear. I'm not here next week. Either hearing today or we'll have to adjourn the matter.
Lordship.
On the prayer of Mr.
K. Kolita, my lord.
K. Kolita, Lanak Counsel for the petitioner appearing in WPC number 5636.
5636.
2021. List these matters. Again on
Saturday, Lordship.
28 to 2024. This was that.
Lordship, this may be segregated because my case is
Well, 28, but that should be, my lord, that can be 27, my lord, because
27, no problem.
27, my lord. Because the 28 is
Okay.
Lordship, matter can be segregated.
You were not same school.
No,
Both,
Lordship,
different
different
schools.
schools,
Different
different
school, but-
selection facts are different.
Facts are different.
No, no,
Even the grounds
selection
are
is,
also different.
Selection process is same.
selection is same, my lord.
No, Lordship, selection is not same.
Selection is
Your
same.
case is, your case name was not forwarded because you did not have that B.Ed degree.
Yes, my lord. At
As
the
per
time.
2000 rule.
You challenge his appointment saying that Parangat degree, 2003, it was not permissible. The High Court passed some orders
Yes.
requiring the amendment, but the amendment did not occasion. It came only in 2018. That's the case.
Yes, Lordship. Thereafter, they are saying, now second affidavit was filed by the private respondent saying that my selection was as per the 2018 rules.
It cannot be because
They are two
Mr.
different contradictory stands.
Just keep that.
Some development subsequently, my lord, the High Court also
The-
passed an order.
Once an
That was
advertisement
the
is
attempt
issued.
was made to deprive the, my lord, the Hindi Parangat and Hindi section, my lord.
I know that.
They're not
but,
selected.
but the
But
selection
that was
having
allowed by the High Court.
the categorical stand of the authorities also is that the
But it-
selection is under 2000.
Selection is as per the new rule, my lord, 18 rule. New rule, my
2003.
lord, as per the selection was made as per 2018 rule.
Anyway, I'm not taking it up. You can try your luck, but that point is there. He is correct. He is not entitled, but that selection may not be proper because that amendment had not taken.
No, the amendment has come and notification also come after that, my lord. After that, everything was done.
Thereafter,
If
free
lordship
selection
come
was-
my lord, the affidavit, my lord, in my.
I've seen it.
Yes, my lord, the Annex 5 and Annex 6. This is the tracks of the case, my lord. Started from there.
Will
Yes, my lord. But that is on 27, my lord.
27. 35. Yes.
Thank you, Lordship. Yeah, Lordship, the grievance of the petitioner is that, Lordship, the person who is having science background, his service is provincialized in the place of the petitioner, Lordship. All along, Lordship, it is also admitted, Lordship, may kindly.
7 and 8, science and Arabic.
Science. I am concerned with 8 already retired. Lordship, so far this, as well as 7 is concerned, I am sorry, Lordship, come to page 49.
There is an affidavit by respondent number.
The department has filed it.
Filed. No, department affidavit is not on record. Have you filed affidavit? Department.
No, sorry, petition.
So respondent number 7 has filed.
7, Lordship. In the affidavit also is that he is having a science background. So here, Lordship, while the district scrutiny committee recommended.
We'll consider. We'll consider. Not today.
The matter is pending in 2020, Lordship.
22.
Now, this is second round of litigation, Lordship. Ultimately, no one is getting any benefit, Lordship. Or Lordship,
List this matter again on 22/2/2024. On the prayer of the parties will.
what's the endeavor made to dispose of the.
That I am not here. I can't make
36.
that observation. If I was here, I would have done.
Lord, oblige.
Yes, Mr. Bhuyan.
My lord, I am a very unfortunate student, my lord. And
That is why you are against your guru.
my lord, it has been compelled to say like this by the, my lord, my guide,
But
my lord.
Mr. Bhuyan,
My lord.
they have filed their affidavit in opposition.
Yes, yes. I am-
Categorical statements. You have not disputed those.
My lord, that is an.
And the stand of the university is that he was not the sole man. There were others.
Yes, my
An
lord. that
average
is-
was taken out.
My lord, that is.
So in
correct,
that
but
view of
you-
the matter, try your luck next time.
My
And
lord,
if you
we
find,
were- My lord.
and see, you participated in the selection with
My lord.
full knowledge that this man is there. You waited till the results came out.
My lord, I do not have any other options left, my lord.
Then you have made all these allegations. Whether
No, my lord, after participation, my lord, these illegalities has been cropped up, my lord.
how?
My lord, that I have stated, my lord, that.
That's
the
your
part- that-
statements. And those facts were there not from
Well,
the
it is,
date of
my
the
lord,
selection,
My
but from the dates, the earlier round
My-
MPhil thing had happened.
My lord, I have to submit.
You have, Mr. Bhuyan, we know Mr. Bhuyan. That's why we are
My-
so openly talking to Mr. Bhuyan.
My lord, these allegations are very difficult to prove, my lord, but it
No,
is
no,
a
it's
fact,
not,
my lord.
it's not that, Mr. Bhuyan. It's
My-
not that. It's not the question of difficulty in proving. You knew that that person is biased against you.
My lord.
And that knowledge you had prior to this selection.
Participation.
You participated. If you had made an application before the authorities, see, I came here, I got to know that this man is there. It may prejudice me. So kindly have my case considered by some other body. We would have understood.
Those conscious.
That thing is missing, and that gives rise to the
That is correct. Lord, can it be taken up after a week or two, my lord, and I will take the instructions. She may not.
No.
like- No, my lord,
What instructions, sir?
my lord, she may not
We'll
like to.
close it.
My lord, my instruction is that, my lord, by another, my colleague, my lord, that she may not like to press this petition, my lord. So, my lord,
Fine, today, if that is the
No, no,
thing,
my lord,
no, we'll go on merits. It's before us, we'll have to dispose it out on
No,
merits.
my lord,
We'll dispose
only one chance, my lord, there because.
Saturday,
My lord,
Saturday.
My lord, could it be on Friday?
Your junior will be here.
my lord.
37, 38, 39.
Mr. Kayal is having a good laugh.
Always.
Yes, Mr. Have you got the,
Yes, Lord.
what is it?
Lordship was asking.
Who initiated it?
EC is the authority, EC authorized EC.
No, where is that EC result?
It is there.
So that is, Mr. Doctor, your case that the initiation was not proper.
My lord, in fact, thereafter the subsequent review, my lord, also not done in time, my lord.
Okay, fine. That is with regard to your suspension.
Suspension.
Lordship, there are.
We are with regard to your departmental proceeding.
Departmental proceeding, my lord, my first case, my lord, is that I was removed from all the posts, my lord, without.
First case, removal.
Yes, my lord.
Second case, suspension.
Suspend.
Third case, departmental proceeding.
There, my lord, I have asked, my lord, the documents, my lord, which are not furnished.
You know that.
I have not
But a
challenged the
further
proceeding.
question arises that there is a indication that the departmental proceeding was not initiated
Well,
by the disciplinary authority.
that is there, my lord, but then the issue here was, my lord, I had
The
asked.
documents that we will go into.
Yes.
But first, let's see whether the initiation is proper.
My lord.
When is the date of the show cause? Memorandum?
Lordship.
No, Mr. Doctor. You can just find that out for me. Mr.
Yes, my lord. It is, my lord, 30/2022, my lord. The first show cause that was issued, my lord. And, my lord, the charge sheet, my lord,
4/11/2022.
4/11/22. Page 52, my lord, of the writ petition, my lord, 8337.
I have no idea. Medium of what? Tragedy fees. Yes.
Page 52, my lord, 8337. the blips.
Yes, Mr. Cal. Have you got it?
Lordship, I've met a chat, I'll assist you, Lordship.
No. Today hearing is not possible. We only want to see
No,
that.
regarding record, Lordship.
Only that. You can just show me that EC resolution.
EC resolution, Lordship, page 411.
Just give me that. Mr. Chaudhary, we have some constraints today.
My lord.
We have some constraints today. This court will rise at 3 p.m.
At
3 p.m.
3 p.m.
So we'll just see whether properly it has been instituted. If that be so, we'll fix it and we'll consider the matter.
Your lordship.
Only I wanted to see whether the initiation was proper.
It's because of the document.
The only affidavit they file in the case where the suspension.
Suspension, second case.
And the earlier case also where he has been.
You have been
from the
removed.
official post, that is also related to the suspension, and we have raised the question.
Lordship, page 411C is one of the resolution where the decision was taken to then page 429, Lordship.
Page 4?
429.
What is the show cause of 33/2022?
Page 28. That your worship will find at page 28.
What is that pertaining to? It's not a department proceeding.
That's not a removal manner. After which I was removed, man.
Okay, that initial one.
Yes.
Yes. Let's see, page 430 is the order of suspension.
Mr. Chaudhary, in your that department proceeding thing, there is an allegation which led to your removal, that student
Yes.
problem.
From the administration.
And then you were asked to hand over charges. That is a separate set of allegations.
Yes.
But Mr. Where is that allegation?
What's it?
Where is the approval for that first charge? Charge pertaining to the period, the charges prior to the direction to hand over charges.
What's if it is there? Page 411 problem.
No, that is earlier. No notice was issued, but in 429,
429 is the order of 429 is the issue.
here this was placed only to the effect
to
after removal, he has not.
authorizing BC2
No, authorizing visit to that extent only.
necessary action and register to reconsider to take his key.
However, Inspector so-and-so did not hand over charges. This are seriously impaired. So-and-so, so-and-so. It was further observed, did not hand over file.
Yes, Lord.
So considering the seriousness of the issue means only this subsequent. Where is the earlier one?
Handing over charge.
Handing over charges. We understand that. And that we are in session of that matter. In one of the proceedings, first proceeding.
Yes, first proceeding.
If we hold, yes, that was bad, then this thing would be justified. But in your show cause, in your memorandum of charge, if you
Memorandum
come,
that there are 3 charges.
Mr. Dotto, it was page 50,
52, madam.
52,
There are 3 charges.
54.
52.
First is
Yes, article of charge number 3.
willful defines to hand over charge.
That 1 and 2 we can understand. But where is 3?
3 is defined direction to higher authority.
Defined
Willful
direction, Raktim Dev.
did not complete by
4.
policy of PSU.
4 is CAS.
Lordship.
3 and 4, where is the
4 is
disciplinary authority's decision? It has to be decided by the disciplinary authority. Disciplinary authority decided on those points, which is after the removal.
No, nothing has been decided till then.
No. That charge framing
Yes, Lordship.
has to be done by the disciplinary authority only.
Yes, Lordship.
So the issues before the disciplinary authority, 3 and 4 were never there.
It is there, Lordship.
No, you check up 429. You can show Mr. Datta also if you want. Only to that extent. Mr. Datta, you can just have a look at that. If you find that it is there, be an officer of the court. 429. Towards the end it is there. End. It's not there.
That is with regard to non-compliance of directive of the Executive Council. The Vice Chancellor.
And over charges, insubordination, all those things. And on the basis of that, the resolution is there.
This is with regard to 1 and 2.
1 and 2. 3 and 4.
Yes, sir.
The VC has incorporated that, fine. But the VC cannot do it without the EC's approval. Anything you put in there has to be by the disciplinary authority only, not the delegate.
No, definitely.
It is a charge. I admit to that. We accept that. It's a charge. grave misconduct, but where is the proceedings to that effect? You can go ahead with that. We will fix this matter. If not otherwise inconvenient to you in the week starting from 4th of March. Let us have it on 5th. On the Mr. SCKL in terms of the directions passed by this court, who had ordered it at 5/2/2024 has produced before this court the original records in original. However, it is not discernible therefrom as to the manner in which the charges against the petitioner as contained in the memorandum dated 4/11/22, more particularly the articles of charge number 3 and 4 were so framed against him. Mr. Gal shall consult the records and apprise this court on the next date fixed as to the manner in which the EC had also approved framing of the articles of charge number 3 and 4. Stop. On the consent of the parties, list this matter again on 5/3/2024 for a detailed consideration of the issues arising in all the 3 petitions. Just that, because if that is not there, to that 2 charges maybe it may not be proper.
I understand.
And then we will see whether the documents are required or not.
Yes, lot.
In fact, my lord, the first, the removal from the administrative office, those are tenure posts. And there is no provision anywhere of removal. So that is by way of a penalty or stigmatic.
Oh, Mr. Chaudhary, we can also look at it in this manner. If there is a allegation that you have committed some wrong,
yes,
then the authorities are not, hands are not tied to take action of removing it. But whether that action is proper or not, that is what we are called upon to. They can always do that. Because we can't say one person is appointed, don't remove him. If there is something, it's like a suspension. You are not suspended. You were suspended subsequently, but at that point of time, maybe they thought that with this man should not continue. If that decision is proper, it now boils down to the show cause memorandum.
Yes.
Everything now comes to the memorandum, because memorandum, if taken forward, established against you, everything gets rectified. But they will have to show that the charge number 3 and 4 were also approved by the EC to be incorporated. I think there are judgments on that line. Please, Mr. Doctor,
Yes,
that without the approval of the disciplinary authority, a delegate cannot find out.
It is there, Lordship.
Mr. Kayal also,
Yes.
There's an officer of court. If there is something done, we will rectify it, then you proceed.
Definitely, Lordship. We are open to that. Much open.
Number 40.
It's not your matter.
Lordship, in this matter, we have filed a review petition, my lord, which is listed today, item number 57. Both the matters.
My lord, this is item number 40 and my friend's matter is connected with 41, my lord. This is not his matter, my lord. This is item 40, my lord, regarding the WPC 8348, my lord.
Wherein we had passed that order that your salary should be paid. Clear.
Yes, my lord.
That case.
Item 42.
No, this one. He has filed a review here.
My lord.
12/1/2024, he has filed a review.
No, that
A
is
review
correct.
to DSM.
That is correct, my lord.
Review to DSM. No. Item number supplement. Item 57.
Oh.
Yes, Mr. Chaudhary, what is your case?
My lord, initially an order was passed, thereby provincializing the service of the petition. The order was there, ma'am. So thereafter, After that order, we approach this is Honorable High Court.
What is the order of this High Court when you approach?
My lord. There lot of cases are there. The final order I'm coming to page 112, my lord.
Of the review.
Review, my lord. The relevant portion, my lord. May I read, my lord? The order dated 22/9/2016, that is the order of provincialization, imputed in WBC number so and so clearly mentioned that the provincialization will not be given effect to in case any court cases involving a school is pending and also in absence of dice court in the year 2019. However, it may be noted that the aforesaid order
Okay.
dated
Thereafter, what happened?
thereafter, my lord, then order was passed, my lord. Thereby, the court directed the special commissioner to pass an order, my lord.
12/11/21.
My lord. Thereafter, an order was passed, my lord, thereby validating his claim, my lord. Thereafter, we approached this honorable court filing WBC number 44/22, wherein this honorable High Court had further directed the commissioner to re-examine the matter, my lord.
Okay.
Thereafter,
So show me a order here which has stayed the direction for provincialization.
There is order, my lord. There is order of stay, my lord.
Where?
In fact, the petitioner did not enhance it, my lord. The order is there, my lord.
Where is it? That this first there was an order.
My lord.
His provincialization was validated.
My lord.
Then you approach this court.
My lord.
by way
Stay
of
order is
filing-
there, my lord. I'm coming to that, my lord.
By way of WPC 44/22.
My lord, that was the last one, yes. Last one.
Wait. That was given a final consideration by order dated 7/2/22.
My lord.
Here, show me where is that order of stay.
My lord, I'm coming to that. First of all, I'm coming to page 112, my lord. The court over here, may I read this, my line for a moment, my lord?
Mister, that is end. That then culminated in the order of the commissioner.
No, my lord. No, my lord. The thing is this, he was provincialized by order date 22/9/2016. That order is there. But the Honorable High Court has categorically stated over here that order can be implemented only after a decision given by the special commissioner, my lord. That is
Okay, that decision is at 12/11/2021.
That is the, yes.
Now you come to that decision, his provincialization validated.
His provincialization is not validated, my lord. Provincialization can be validated only if a justifiable order in his support is given by the.
So what is this order at page, the order dated 12/11/21?
That is the order we challenge in the writ petition, my lord.
Okay, that's what I'm coming to say.
My lord.
So this order, you presented a challenge in 44/22.
My lord.
Right?
My lord.
That was disposed of on 7/2/22.
My lord. My lord.
In 7/2/22.
Page 124, may I read, my lord?
So that was interfered with.
That we interfere with by saying that the earlier order passed has to the special commissioner did not comply with the earlier order, therefore directed to proceed with this again, re-verify the matter in compliance of the earlier order,
Then
my
the
lord.
order comes.
My lord, the impugn order comes.
25/5/22.
My lord.
What is the effect of this order?
My lord, the effect of this order that the special commissioner has directed and to forward the case to all the three persons over here, my lord. Not only the petitioners, but the review petitioners also, my lord. All the three, my lord. The decision is at page 103, my lord. $119, my lord.
What is the date of that order?
25/5/2022, my lord.
Come to the decision, director.
My lord.
Okay. Then he files 5620.
My lord.
Right?
And by this, that order has been stayed, my lord.
No. By this, he files this, and this court on 31/8/22 stays that.
My lord. My lord.
So by that stay, what will happen?
The stay, what will happen, my lord?
He has a provincialization order in his favor.
Absolutely.
So this, everything culminates to this.
My lord.
That is stayed.
Yes.
That order gets revived.
No, my lord.
That's your contention.
No, I'm coming to that, man. I'm coming to that. May I have page 112, my lord, for a moment, my lord. May I read this for a moment for this page? This is the main battle page, my lord. Yes, sir. Yes, sir. Yes, yes.
Okay, you mean to say that this court said you implement after an order decision is arrived at by the authorities.
My lord.
Decision arrived at,
My lord.
put to challenge,
My lord.
and again interfered with.
My lord.
Subsequently, so you mean to say that all orders in his favor has gone?
I'm not saying that all orders in his favor are gone. I'm not saying that, my lord. I'm just saying that A plus B is equal to C.
Now tell me, what is the status of the provincialization order in his case? Where is your provincialization order, Mr. Bhuyan, in the writ petition?
Page number. No, this is that page 73 in the writ petition. Annexure 19 million.
Has this order been interfered with till date?
My lord.
Where? Set aside.
No, it has not been set aside. But
so issues are being considered. We'll also consider that.
No, my lord.
But this order from the date 22/9/2016 is continuing.
It's continuing. It is
the
continuing.
issues, whether this order is valid or not, that is being considered by the courts.
One thing is added over here by this order, my lord, that for implementation of this order, there has to be a valid order by the special commissioner. That is the crux of the matter, my lord. The petitioner over here has dependent on an order of the special commissioner, my lord. Unless and until the special commissioner passes an order in his favor, that provisional order lies dormant, my lord.
Have you received any salary before?
No, my lord.
Not till date, no.
Because the post, my lord, the two posts are still lying vacant.
What is your claim against him? You are claiming science.
Two of us. I am a science teacher.
And he?
Science and math. He is also a science teacher. Another.
Who is senior amongst you?
I am the senior. I am appointed in the 1991. He appointed in 2008.
Why he was not given, Mr. Bhuyan?
My lord.
Forget the decisions. You tell me the facts.
My lord, the fact is that regarding the seniority, my lord, I am the senior.
He is the senior, but he is
My lord, the
assistant teacher only.
he is the assistant teacher, my lord. His appointment not as a science teacher. But I had been especially appointed as a science teacher, having the my lord BSc.
What is the dice data? Okay, now come to that order.
My lord.
That impugned order in your writ petition.
My lord. Lord, may I submit regarding the review petition, my lord?
I think this is the case wherein we had formed a view that it was a sudden conclusion without even considering the earlier matters. I think that was the conclusion we reached.
My lord, because it was an interim order, my lordship was pleased to pass. And my lord, salary part, my lord, I think my learned friend should not have any grievance because, my lord, it is not his exchequer by which he is going to pay. My lord, it is only due to ego, my lord. He is now come up with this review. I am not taking over his right, my lord. If he is going to succeed in the petition, my lord, or my writ petition is dismissed, then, my lord, he will get. I am only on the salary part, my lord. Now, how he is affected, my lord, if my salary
I'm
is
really
paid to
affected,
me,
my lord, because his if
my lord,
salary
I have not interfered with my respected friend, my lord. So, my lord, the review petition which has been, my lord, projected is, my lord, there is no error apparent on the face of the record, my lord. If we go by the order passed by my lordships, my lord, they have to show that there is a error apparent on the face of the record, my lord. But there is nothing in the pleadings as well as on record in the review petition, my lord. And on that day, my lord, my learned friend was also present. And on that day, he never hesitated, my lord, regarding this payment of salary.
I did, my lord.
Come to page 103 or 127, whatever it is. With that order dated 25/5/2023.
Thank you.
My lord.
Document now,
Come to point number
126.
6. Now, the thought process here seems that he was considered under the 2011 Act,
My lord,
right?
my lord.
Now, that is you will find in para 5.
My lord,
Huh?
my lord.
Then 6. 6 says that link case was conducted so and so, so and so, so and so. Now you come to that 6th part at the next page. Was provincialized so and so, which was prior to declaration of the provincialized and unconstitutional by so and so, stay order was withdrawn. So and so, so and so, so and so may examine the matter of provincialization, so and so under the provisions of so and submit proposal accordingly. Since the Assam so and so is no longer exists and Moinul Haq was holding the post of assistant teacher, additional post of assistant teacher in so and so, claim of provincialization service cannot be considered. Order dated so and so, directed is to take a validity of the order dated 22/9, which apparently was passed under so and so. Therefore, a decision be arrived at without taking recourse to the act of so and so, in the meantime being declared ultra vires. Accordingly, the reason order so and so was revisited under the provisions of the so and so 2017. As per so and so, all rules that shall repeal, however, all teachers of so and so shall be continued, be reviewed as per the eligibility norm set for so and so. In the said section, relief was given by allowing continuation. In view of the above, we'll process the matter of provincialization service in respect of the petitioner as well as so and so, as per provisions of so and so, with due recommendation from the so and so, and by placing the proposal so and so, this supersedes so and so. Now, where have he set aside the provincialization order? This is a total perverse reasoning, because 2011 Act gone. Now 2017 has come, so there is a provision that we will have to review. We will review. In that view of the matter, send it back to the DSC under the 2017 Act. That was never asked by this court.
I'm not on that much.
Yes, who is appearing for the elementary? Madam, have you read this order? Correct me if I am wrong. Both of you, Mr. Bhuya, Mr. Chaudhary. The thing is, 2011 Act gone. So under 2017 Act, your cases have to be reconsidered. Section 24. So, madam, have you implemented Section 24?
No.
Then, today onwards, we will direct for review of all cases under Section 24. What is this order? We will recall the order, no problem. We will recall it. But this order was rightly stated by this court. Why I am saying so? Because now they have not sent back your cases because of the interstate dispute. They have sent it back because 11 gone, 2017 has come, and 2017 requires reconsideration. Let it be applied across the board to all.
My lord, that is there, but it is the petition who stated, my lord.
Fine. We will say, now today onwards, we will start passing orders, madam. All the cases which come to us, we will say, no, all provincialization bad. We'll make a declaration in a particular case saying that all provincialization of 2011 is bad because government has decided everything has to be considered under 2017. Done. Finished.
Let me have my instruction, my lord, because 2000, in this case, my lord, till date I have not received the instruction, my lord.
Go through 2000, that 25/5/2022 order, and then make your submissions. Saturday. Coming.
My lord, my salary has not been, my lord, it was a direction for 10 days. Or till date, my lord, no salary has been paid.
No problem. We'll look. There is an issue. Let us get over that first.
My lord.
My lord. My lord, one thing I mean.
My lord, he has been receiving salary from the from month of January, my lord.
Who?
I have the petition, my lord.
Receiving?
Yes, sir. No, my lord, we do not have any inspection.
Mr. Bhuya has not got his MI. That is why. Mr. Chaudhary,
my lord,
make your submissions on Saturday on this point.
My lord.
List this matter on Saturday.
Is it possible for Monday, my lord?
No.
Okay.
Saturday. As the first item. 10:15. And give me your views on that order. Because I clearly remember why we passed that order. Because of that reason.
One thing is this, my lord. As the 2011 Act says, my lord,
See, if his case, we go by the analogy of the authorities,
My lord.
his case under 2011 was perfect.
It cannot be, my lord. He's junior.
No,
to
no,
me.
that is your contention. That will be seen.
As per the rules, my lord.
No, no. As per the act, as per the decision of the authorities, till that, before that order,
My lord.
under 2011, he was found to be perfectly correct.
Because he was graduate, my lord.
Perfectly correct.
My lord.
Now, the only conclusion in 22, correct me if I'm wrong, 22.5.22 is that because 2011 Act is gone, it has to be done under the 2017 Act. So, we will have.
That is there, my lord.
No, if that is there,
My lord.
then your review will be dismissed.
My review is not for the 2017, my lord. My review is that his case can be considered, but after it, decision has to be given by the special commissioner.
We will add a line if required.
My lord.
We will add a line,
my lord,
if required.
My lord.
We will not stall the process, but we will add a line. We will dispose of the whole matter. But his order of provincialization stands still today. And that order you are referring to has already been implemented. Subsequent order does not have that thing. Validity of that, like we say, subject to outcome of the case.
My lord.
It is subject to outcome of the consideration.
But the moment this impugn order state, the earlier order passed by the Order that gets revived because the order says that can be implementation part is there.
That order is already gone. This is a fresh order. This relates to the provincialization. The things that have taken place in between, gone. It is this order and the provincialization order. Validity. Satisfy me on something. Mr. Bhuya, you also do your homework.
Yes, yes.
41.
We'll have it next week.
My lord.
List this matter again after 2 weeks on a date to be fixed. After a week on a date to be fixed by the rest.
First week of March. My lord. Oblige me.
42.
May it please your lordship. In this matter, I am appearing for the respondent number 9. I have been the authority. Today, your lordship, I filed the authority.
Okay.
So your lordship, I will also
Mr.
require some
Y.S.
time.
Manan.
Yes.
Y.S.
file
Manan,
affidavit.
learned standing counsel. Oh,
No,
learned
I am
counsel.
for the respondent number 9.
Enters appearance for respondent number 9. Also, accordingly, matter stands adjourned to be listed after 2 weeks.
We'll file affidavit 4 weeks.
4 weeks. 4 weeks on a date to be fixed by the rest.
Much obliged. Oblige.
44.
List this matter again after 2 weeks on a date to be fixed by the registrar. Oh.
My lord, this case, if your lordship remembers that my name was not there in the dice code, but because of the.
We wanted to dispose it of today.
Yes, my lord.
Today it will not be possible.
Okay, man.
List this matter after 2 weeks on a date to be fixed by the registrar. Next day it comes, we'll try.
My lord, would it be 5th of March?
Too much. Let it come. It will come. It will come. Don't worry. After 2 weeks, it will come. Or you make a mention.
45.
Your affidavit is on record, Mr. Roy.
Affidavit has 2 affidavits in file, my lord, one by Seba and the one by.
This is a reverse. Normally what we get, this is the reverse.
Yes.
He wants his age in the higher level. Why are you not giving it to him?
No, Lordship, my senior is today not feeling well.
Mr.
T.C.
Shetty, okay. On the prayer made on behalf of Mr. T.C. Shutia, list this matters again after 2 weeks on a date to be fixed by the registrar.
Check the kindly a date may be given, my lord, because the urgency is there, my lord.
It will come 2 weeks, make a mention. Yeah.
Oblige.
48.
48.
Lekha. Mr. K. Gogoi, learned Standing Counsel, Higher Education Department, has placed before this court the instructions received by him pertaining to the compliance of the orders passed by this court. The instructions reveal that the director has already place the proposal after the requisite processing made before the secretary to the government of Assam, Higher Education Department, full stop. The order, compliance of which is pursued in the present proceedings, in the order, compliance of which is pursued in the preceding proceeding, a direction was issued requiring the appointment of the petitioner within a period of 2 months from the date the college authorities after selection recommends her name. Full stop. The college authority on conclusion of the selection and finding the petitioner to be placed at serial number 1 in the merits, recommended the name of the petitioner. Full stop. It is seen that the authorities are now delaying the approval that is required to be granted in the matter on grounds which are not at all tenable. The communication dated 12/2/2024 as placed before this court reveals that the authorities are now questioning the very basis of the order dated 25/11/2019. Although the authorities had not proceeded to get the order assailed in any forum or by way of filing a review. At this stage, it is not open to the authorities to question the basis of the said order, inasmuch as the said order can be held to have attained its finality. On the next date fixed, the secretary to the Government of Assam Higher Education Department shall place on record through the Standing Council Higher Education Department the approval as granted to him by him to the proposal as submitted by the Director of Higher Education in the matter. In the event the proposal is not approved, necessary orders drawing up contempt of court proceedings against the said authority shall be considered to be passed by this court. List this matter again on. When do you want it?
My lord may indicate against the secretary, Lord.
Secretary.
My lord may indicate secretary.
Against the secretary, huh? When?
Any day, Lord. I will forward it, Lord.
20,
I will not forward it. My brother will forward it, Lord.
28.
Yes, because the communication against me, Lordship. So
28.
My brother will forward, Lordship.
28 to 2024.
Obliged.
Full stop. Mr. You will forward.
S. Das.
Mr. S. Das, Learned Standing Council Higher Education Department, is to take notice of this court and forward a downloaded copy of the order to the secretary for necessary compliance.
They are questioning the submission, Lordship. A court order, they are not granted the court order, Lordship.
We have not brought it on record deliberately because may be not proper because it's an internal communication between you and the authority. But I think we have brought the essence out.
Let's
see. You produce, the secretary to place the necessary compliance report through Mr. S. Das before this court on the next date fix. List this matter again on 28 to 2024.
All right.
Yeah.
49.
May I please, Lord?
49, my lord.
Complied with.
So, my lord, the direction was to the secretary to transmit the record to the special state level committee. And the state level committee on 9/2 has conducted its meeting and has, your lordship will kindly peruse the minutes of 9th of February. To pass the order, my lord, some queries has been raised by the special state level government.
Mr. B. Kaushik, Learned Counsel for the respondent has placed before this court the minutes of the meeting of the Special State Selection Board held on 9/2/2004 and submits that the matter is under active consideration and prays for 2 weeks' time to place on record the compliance report thereon. Also, accordingly, list this matter on after 2 weeks on a date to be fixed by the registry and the compliance report as compliance report as directed by this court be placed on the next date of listing.
Edit date may be given.
2 weeks.
Item 50, my lord, it's complied, my lord, applied. That
50 complied with.
50 complied.
What was the direction?
Was my lord, this item 50.
50 to paise nahi. The orders have been passed.
My lord.
What is the order?
But it is rejected, my lord. That there is no provision for regularizing the service of an honorary grade 4 in a provincialized school as per the rules.
But there was a selection process.
And the principle laid down in that case is that in view of the above, the for regularization of his honorary engagement is hereby rejected.
No. This is something else. 4270.
Item 50. WBC 4270. Contempt is 501 of 2023.
4270, 24/8/22.
My lord. The order is of 24/8/2022.
24/8?
24/8/2022. Petitioner was directed to submit a representation and on that representation.
Mr. B. Kaushik, learned counsel for the respondents, has placed before this court an order dated 13/2/2024, by which the case of the petitioner was considered in terms of the directions passed by this court-wide order dated 24/8/22 in WPC number 4270/2022, and the same was rejected for the reasons assigned therein. Full stop. The order dated so and so on perusal satisfies the directions that was passed by this court, wide the said order, and accordingly, there is no deliberate and/or willful violation of the directives passed by this court. Also, in view of the above, the contempt petition stands closed. However, liberty is reserved to the petitioner to assail the order dated 13/2/2024 in an appropriate proceeding.
Hello.
The copy of the order dated 13/2/2024 as produced by Mr. B. Kaushik is kept on record and marked as X.
Well,
this protocol.
Obliged.
The hearing matters, we will have it next week.
53.
Because I'll have to raise. We'll have it next week.
Date में fix your lordship. Item number 53.
52. 53, 54 likha, 53 and 54. List this matters again on 27/2/2024 for further concept, for hearing.
My lord, when you are
27.
my lord.
Yes, yeah. Yes.
My lord, can it be 26th, my lord? If not 27th.
26 really.
My lord, please.
Mr. Mahmood.
Yes.
This matter, we will have it on some other day. 51, 52. Okay.
Yes.
List this matter again on when it will be convenient to you.
Except in 22 or any other date.
20th, 20 on 2/02/2024.
Interim order may kindly come.
The interim order passed earlier shall continue. Anything more? Hardship?